had happened on present eviction. I came before the
That we understand.
and an order was
Initially, there was no interim
There
order.
was interim
Then you
order
file an application. Then interim order was
Interim
granted.
order was actually dictated, but it was not.
Okay, we understand that.
Yes.
Okay.
And
Restraint from evicting. Restraint from evicting.
Yes.
Okay.
Now
Your
what has
lordship is
happened?
taking item number 1.
So it's evicted.
Now what has happened on 26th of February? 26th of February, page 93. I will if my short right take page 9. They came with tractors and bulldozing the crop at page 93, and then series at page 100, 101. They have put a barbed wire, and people are confined inside the place.
You should be in the contempt now. Who will direct you?
No, lordship. I was humiliated once because of that, lordship.
Why?
As per direction of this honorable court, I appeared, lordship. I sent a letter, not in this case, in other case, lordship.
Okay,
But,
call
did not
Mr.
respond
Call
to
Mr.
me.
Nath, senior government advocate, after some time.
Yes.
Call Mr. Nath, senior government.
Item 2, lordship, I am.
Item 2 will take there.
In item 2, lordship, I had a discussion with the deputy commissioner yesterday, lordship. He has stated certain facts to me, lordship. So I told him to corroborate it with all the documents. Accordingly, because of the election, lordship, he is praying for some time.
No problem, we'll grant a time.
But item 1,
But
lordship, is a contempt.
apparently, the photograph shows that you have the state has fenced the area. If that be so, then and you are aware of the order.
In contempt, lordship, I have nothing to say.
So therefore, we want the since generally what we do is we ask
Yes,
the
lordship,
government.
in
So
one case,
since you are saying that, we will call the senior government.
in one case,
At least
lordship,
you'll have the authority. Yes,
was-
no problem, no problem.
lordship, because of that, otherwise, lordship, I am.
Yes,
Lordship is taking
Pathak.
up the item number 2 also along with item number.
Yes, Pathak. Records are there, same.
No, this is another challenges.
No, we understand. Challenge out of the same district.
Same district.
Same district, same issue. So when we are taking this
Tomorrow.
matter? Tomorrow. We are taking it up tomorrow. Okay? Tomorrow along with the
Others.
okay, on caveat. Okay. Should we pass any order today? Tomorrow is there. You will not. They will not construct the house and start tomorrow. Please this matter tomorrow, as it is submitted by the learned counsel for the parties that similar matter being WPC 1384 of 2024 is fixed tomorrow for consideration. Please recording.
Okay.
Huh? That's it submitted. That is submitted. Interim is there. Being search sheet number.
CS number 1298/2023,
Uh-huh.
dated 30/11/23, under section 306/498A.
Okay.
All after list is over. If time permits. Otherwise, we'll take after view. Out of this 64 methods, huh? Steps is complete. This matter is ready as regards subject. Accordingly, list this matter on give a Tuesday or Thursday. After view. We'll fix in order. We'll take the first 29th of April.
Public.
Yes. Item. Yes, what is the correction?
On the CR.
Uh-huh.
CR case. It should 704.
GR case, where is that order? Please come.
It-
Case.
It starts with the 12.
It's 30.
So there was an earlier typographical order. Then you have not sought for this correction.
Not the type, not the other was my type.
So how can we correct this?
CR.
Where is the order? That page 15. Hard Mr. Spencer. It submitted that the GR case number 704/2021 reflected at
Not. Not.
the equal the GR the is submitted by the petitioner that the bail petition was filed in connection with GR case number.
704.
Then it is correct.
No. It is
Order.
order last page ballot.
No. What was actually the GR case number?
13.
704 of 2013. However, inadvertently, the petitioner has typed the GR case number to be 704/2021 instead of GR case number 70/2013.
704.
704/2013. Accordingly, this court in its order dated 4/1/2021. No. In its order dated
4/1/2023.
order dated 25/8/2023 and in order dated 21/12/2023 recorded the recorded the number of the GR case to be GR case number 704/2021 instead of 2013. Accordingly, the present application is filed for correction of such. You ought to have filed an application for correction of your pleading.
No, but correct. It's IA for what I have
IA.
earlier order.
Uh,
In that case,
So you'll have to file an application for IA. These are technicalities.
That
Is
already,
not it?
that is already
Dispose
disposed
of. Okay. In IA, pleading on the IA. However, it was correctly typed in the connected criminal appeal, being criminal appeal number in criminal revision petition number.
344.
Don't commit mistake.
344.
344/2023. Considering the matter in entirety, it is provided that the GR case number 704/2021 in the order dated 21/12/2023 be read as GR case number 704/2013. IS stands disposed. Yes, what is this?
I did. I
Hmm.
praying for amendment of the relief claim in petition.
Hmm.
And are there. But heard the other day.
Yes, Mazumdar.
Now they have filed an IA for amendment of the writ petition. Okay, they are trying to enlarge scope of the writ
So
petition.
file an objection.
Yes.
The present application is filed amendment of the connected writ petition including the prayer.
Only the prayer.
Connected amendment of the prayer made in the connected writ petition. Mr. Moti Majumdar, learned senior counsel representing the state respondent submits that by way of filing the application, the writ petitioner are trying to enlarge the scope of the writ petition. Accordingly, the state would like to file an objection to the IA.
And they are trying to improve the
Okay. Prayer stands allowed. Please this matter after 4 weeks.
after court.
After 4 weeks, in the meantime, objection may be
And let us have on 25th.
25th of April. Let this matter be listed on 25th. Yes. No, just wait. Mr. Madam, give a copy to him. Show him. See, here is a case. They say that we should not be evicted. This court initially, according to them, passed an order. Detailed elaborate discussions were there, but there is no interim order. Then they file an IA. Court says yes, discussions were there. It was a mistake. So interim order was there not to evict. According to them, it was intimated to the deputy commissioner and all. Now they have filed a contempt petition. In the writ petition, Mr. Sharma says that they will have some instruction and file affidavit, no problem. Now they files this contempt with an allegation and with some photograph that their cultivated crops were demolished, and where they are living, a fencing is erected by the administration. And they have an next photo where the minor children see the photo. If it is true, it is not a state action, it is an atrocious action. If this is correct, see the photographs. So we are taking it up day after tomorrow. We hope and trust that if you have done this, whatever you have damaged, if you have created a fencing blocking the ingress and egress, then better you remove and come. I think good sense will prevail. If that is done, that cannot be at any rate. Even if you have done eviction, if it is no interim order is passed, you cannot keep people like this. This is not a action of the, cannot be an action of the state in a society which is governed by rule of law.
I'll take the instruction.
Where is the contempt? Give the contempt. The present contempt petition is filed alleging willful and deliberate violation of this court's order dated 2/3/2023. Yes, madam. 2/3/2023. Passed in IA Civil 606/2023. 2023 in WPC
WPC number 809
2020-22. By the aforesaid order, this court has directed restrain the respondents from evicting the writ petitioner from the land under their occupation until further orders. The present contempt petition is filed alleging that though such order was duly served upon the respondents, that is the principal secretary to principal secretary commissioner and secretary to the government of Assam Revenue Department, comma, the deputy commissioner Sonitpur, the additional deputy commissioner and the circle officer of the concerned circle. However, the aforesaid respondents has erected fencing over the land in the boundary of the land of the petitioner, stopping ingress and outgress of the petitioner, and also demolished the growing crops of the petitioner. In support of such contention, the petitioner have annexed certain photographs, which, if correct, is really disturbing. In the aforesaid backdrop, though it is a contempt petition, this court has requested Mr. D. Nath, learned senior government advocate, to apprise this court whether the story, the case projected by the petitioner is correct. List this matter Friday.
On Friday,
22nd of March. A copy of the contempt petition be furnished, 2 extra copies of the contempt petition be filed to Mr. Dina, learned senior government advocate.
may I get a copy of it?
Huh?
Copy of it.
And also a copy of this order. A copy of this order also be furnished to Mr. Dina.
No, fine.
Full stop. Registry to list this matter showing name of Mr. Dina, learned senior government. So far relating to other matter, Mr. The writ petition item number 2,
Lordship,
Mr. H. Sharma,
last
learned
part of May, Lord.
counsel submits that he has received some instruction, but
Supported
such are
to be, sir.
not complete, and he has asked the concerned officials to give supporting documents, as regards the instructions submitted. Accordingly, he prays for an adjournment. Full stop. Prayer is allowed. List this matter
Last part of May.
in
That's
the
because the election,
election.
after 19 they are praying.
List this matter. List this matter in the last week of March, May 2024. Interim order that is until further order.
Acted.
Contempt for the time being separated.
That is hectic.
Hmm?
31st of
31st of May. Result will be over. I think they will be busy for this election
yes,
result.
Lordship. Let it be in the month of June or July, as because this contempt most
Okay.
probably everything.
So
will be
therefore,
covered.
we are saying after 4 weeks,
Lord,
after 6 weeks. So you make a mention if urgency is
let
there.
it be after 8 weeks. Lord.
8 weeks.
Acted.
Yes.
Regarding beneficiary list of Pradhan Mantri Award Yojana Gramin. Now, the petitioners have been also selected. They have
Oh, file an affidavit. Who are you?
Yeah.
Huh? For penalty. You keep his grievances that we are deserving. Until and unless there is specific record, we cannot do a roving and fishing inquiry. Who is deserving?
now the list is there. Now one there, our application is filed for let the deputy commissioner exercise if we are entitled, let him exercise.
No. We do not want a contempt. At least let us have some satisfaction.
Well.
Okay, let us have some satisfaction. When? The prayer of the learned counsel for the respondent, enabling them to file affidavit in office. At least after 3 weeks. No.
Apply.
After 2 weeks, it will go after 3 weeks. After 2 weeks, there are holidays.
Was better.
Hmm.
Where the below that below. I got the order.
Yes, where is Mr. Gogoi?
I have affidavit.
Today, okay,
Finally, okay.
where is the assessment?
So first of all, I will take it out of order of the
Ah.
It starts at page.
Gogoi?
What?
They have filed the affidavit for the reason of bias. You do not want to do the case today. Where is the affidavit?
Pilot, the morning I filed. Here, Pilot, one thing may I point out, there are two more assessments. In fact, my learned senior was placing the judgment. In that case, in two cases, relief was granted.
Ah.
What was the assessment there in Melo? If that is placed, even I have asked from the authorities, where Melo it has been shown as nil demand.
Ah.
For that, honorable court Melo said that they won't be
Here
any
his
interest.
case is that when there is a nil demand,
Yes.
you cannot have a uh, uh, penal interest and assessment of
Yes,
interest,
yes.
etc. Because this court in no unambiguity has dealt at
File
section 20,
division bench, Melo.
division bench, section 22 in terms of transfer, you cannot have that.
But at the same time, Melo, in rest of the other four cases,
Hmm.
liberty was given to us. The direction
Liberty was given to us.
that you,
Now, therefore, I
re-verify
think
under 22.
what is your case now? That
Sir,
was
that-
it a nil balance or it was not a nil?
Nil balance, I will show you.
That's why, Melo, the base
Where in the
53
order?
Lord Supreme.
I will just show you.
No, Mr. Uh,
Page-
Saraf, just tell me one thing. Why they have said? So they say, their whole ground is that amount of rupees 50394 lakh was due on 34/1999,
Yes.
but it was paid on 56202. So are you calculating the interest for this period?
Yes, my lord. Not on, my lord, demand, but on delayed payment.
But
They have paid the payment. In fact,
Okay.
my lord, all entire amount has been paid.
my lord, the provisions of the act, your lord.
Ha.
The act, on the court anticipated the provisions of the act. Section 22.
Hmm.
And thereafter came to conclusion.
Huh.
That if the demand.
So there is no dispute on your side that payment was made. There was nil balance as on 56202.
Nil balance mean that doesn't mean that, my lord.
No.
Yes.
Nil balance means according to you, the principal was paid on 5/6/2002.
Yes.
Okay.
Yes.
And it became due on 34/1999.
My lord, we'll see subsequently. Means, my lord, from 2002 onwards, on part payment they have made and finally they completed the amount. It's not that at a one go they have paid. And subsequent. It is there in the impugn assessment order.
Okay, we'll come to that. So according to you, it was paid.
Yes.
Payment was made, no doubt about this.
Fine.
Principal amount is made,
Got it.
but there was a delay from the date due to the final payment. So therefore, you are charging interest on this.
There is
And
a sort of a
therefore, that
compensation.
nil balance was not there in your case. That is your
Yes,
case.
That's the difference.
And you
between
have
the
not
other case.
charged any interest subsequent to the final payment. This is your case.
Yes.
Okay. Let us see the rule 22 that has been interpreted in the judgment.
Implement, you also may want to see the rule.
Hmm.
Section below.
Hmm.
I've given the.
But this is appellate order is at page 58.
You'll also see, my lord. I will take one line, my lord. In the appellate order.
We have marked it. Paragraph 13.
13. Therefore, levy of interest for the amount paid after subsequent delay is negligible. The appellant manifestly made an attempt to mislead the court by not submitting the factual position. So they are also not submitting that this the court has directed that the interest will not be leviable. Their allegation is that he will not mislead the court
by suppressing facts. Now this has been, SLP against this has been dismissed with the direction that interest as per the statute.
Interest as per the statute.
Statute.
Now, what should be the interest as per the statute when leviable? That has been interpreted in the division bench judgment itself.
That the statute, as per the statute, interest is not payable. The last mistake page, the judgment starts
Page,
page 43 and the relevant part at page 50 below.
page 43.
43 starts and page 50. Page 50, para 6.
Page 50.
Page 50, para 6.
Okay.
In the cases in hand, the earlier assessment orders and demand notices passed as set aside by Supreme Court with a direction to de novo assessment. And after de novo assessment, it is found that there is a nil demand for the assessment year. Therefore, the question of payment of interest for the nil demand does not arise. In that view of the matter, the application numbers so are allowed according to the implement orders are classed further.
Okay.
However, in respect of the application numbers and so, the demand notice.
So these petitions relates to the present litigation.
So these petitions are two petitions which were closed of law. That went to the apex court. So the apex court said that the asset is missed, but the petitioner will be liable to pay interest as per the statute.
Okay.
Now we'll also see. However, in respect of the application number so, the demand notices issued for payment of the balance of interest is not clear whether there was any tax liability preceding the demand notice, whether the difference of liability is more than 10% between the returns and the demand notices. In this regard, the Supreme Tax is directed to verify and pass rest order in accordance with law in order to section 22 of the. So what the middle of the assessment authority were directed to see that whether there was a tax demand.
Tax liability preceding the demand notice.
Of demand notice.
Okay.
Now, if the demand notice, there was no tax demand, this honorable court has not directed the assessing authority to re-examine section 22. No. The assessing authority is saying that the honorable court directed him to re-examine.
Okay, now this went to Supreme Court.
This went to Supreme Court and Supreme Court order will ultimately in the compilation.
That is there.
Page 55. We are not inclined to interfere with the impugn order. It is also noticed there is a delay of however, we clarify that in terms of the judgment dated of the Supreme Court in entitled the respondent in corporation limited would be liable to pay the differential amount along with interest as per statute. Now, if this honorable court.
Where is the judgment 2007 that has been
Well, I have elected
in the compilation? Okay. Page?
It is you'll also find page 57.
Page 50. Next.
Melo. I'm sorry, but this is very good. I'm giving separately,
Okay.
Well, I may tell you how the matter went.
That's right.
Because earlier, these petroleum products were taxable at the point of first sale in Assam. Now, as per explanation to section 8(1)(a) of the HGS, it provided that if the oil company purchases the goods from other oil company and this sells the
Here it is BRPL.
and this sells the same in the state market, and the difference for the purchase price and sale price more than 40%, then the second sale will be treated with the first sale. Now, the amount as per the respondent, it was more than 40%. The contention of the petitioner was that the difference is not 40% because this amount is collected to the direction of the oil coordination committee, and the amount is contributed to the oil coordination committee. So the 40% doesn't remain with them, and thereby the second sale cannot be treated with first sale. Second contention was that when in any case, even if the sale is treated to be the first sale, whatever tax has been paid at the first sale cannot be mirrored, it cannot be double tax.
Double tax.
Because I have paid first, I'll purchase from here. Now, even if by virtue of the execution without the second sale is the first sale, then also the tax that has been paid, we failed in the deposit on the board, and thereafter in the matter went to the Apex Court rejected the first content of 40%, but said that the amount whatever has been paid, that has to be given credit.
That is done in 2007-11.
Hello?
That determination made in
Thereafter, the Supreme Court not set aside the judgment of the
division bench and single bench.
single bench as well as the assessment order,
Okay.
and directed the assessment authority to verify whether the tax has been collected on the full amount from the customer. And if that then has to be paid on the ground of injustice. After the assessment was completed, the assessment authority found that no, the amount was not collected. And he gave the credit of the amount, and nothing was found to payable. Because prior to the Supreme Court judgment, with a memorandum of understanding between the government of India and the state of Assam, the IOC was directed to pay a certain amount on account of tax subject to the result of the SLP filed before the
Okay.
Supreme Court. So the amount was paid. Now the assessment orders were set aside. Now, as per the Supreme Court has been referred to by the division bench, if the assessments are set aside and the de novo assessment is made, and there is no demand, that interest is not payable because of the provisions of section 22 of the Act.
Okay.
If you look into 22, I will also, irrespective of the the Apex Court, I must certify also that as per section 22,
Yes,
the
of
interest
course.
is not payable at all.
Of course.
Now, on the basis of that, the interest also was levied. When interest was levied, we came before the Honorable Court, and this Honorable Court found two assessment years, the demand was clear, that there was no tax demand. So set aside the assessment of levy of interest. In 4 assessment years, the court was not clear as to whether there was any tax demand or not at time of the demand notice. The matter was demanded back to find out whether there was any tax demand prior to issuance of the demand notice, and to pass the orders accordingly. Now the assessing authority again re-examined section 22 of the Act and said that no interest will be payable as per section 22 of the Act. We went in appeal, and in appeal again, the appellate authority has again re-examined and said that yes, here whatever has been done by the assessor is correct, because he misrepresented
Before this court.
and suppressed the fact. Now, my submission for that with appellate authority and assessing authority cannot sit over the judgment of this.
So your argument would be, irrespective of having no power or not to levy in terms of section 22, the additional ground is that this court has already determined and remanded the matter back to you only to determine whether there was already a tax demand, tax payable prior to the
issuance of the demand notice.
demand notice.
If the demand notice there is no tax demand, interest will not be there.
Not because.
Now, the 2 assessment years which were there at that side, by the court, there was only the ground that the demand notice, there was no tax demand. Now, better went to the Apex Court. The Apex Court has upheld the judgment of this Honorable Court and only observed that interest will be payable as per statute. Now, as per statute, this Honorable Court has only found that interest is not payable if there is no tax demand on the demand notice. So the finding of this Honorable Court has been upheld. So now, to say that
So even if even if in terms of the Supreme Court judgment, there is nothing to be decided because the High Court has said that there is no tax demand, no,
interest will not be payable.
there is no.
And that has been reached to finality on dismissal of the SLP. On dismissal of the SLP, this judgment has reached the finality. So the observation of this Honorable Court to the effect that if there is no demand, tax demand as per the demand notice, interest will not be payable. That is the law of the land. Now, no power is conferred on the assessing authority to sit over the judgment of this Honorable Court. and to interpret the section independently. Because they said that they have suppressed and so on. So they could have said in the Supreme Court. They went to the Supreme Court.
So far relating to determination on the principle of law is upheld. Only thing is that as per section 22, they have been asked to they can verify
whether, as per the demand notice,
Hmm.
any tax was payable or
able
not.
on the
And from the assessment order, itself, we also find that there was no tax demand. The tax
let us
demand,
see that portion.
well,
That
I
is what-
told you, Lord, the Lord, we find the order of assessment at page 52.
52.
At page 56, you'll also find
Now they have reassessed
pilot.
at page 50.
You'll also find in the, first of all, I will take it.
This is notice of demand.
Notice of demand, you'll also see the back side below on the you'll also see page 54.
Page 56,
Page 54.
54. A sum of rupees 6080.
Page 54.
Uh.
A interest before the next turnover so interest after next turnover as below.
Page 54.
54.
Okay.
Now we'll also find tax payable.
Hmm.
The amount is mentioned.
Where page 54, tax plus that tax, April
Tax
1980.
payable and paid for the different assessment year. This is part of the assessment order.
Page 54.
Page 54.
Part of the assessment, drawn up assessment order and issued a demand notice.
Well, I think,
There is a tabular form.
well, in fact, I was taking your page 1708.
WPC
1708.
1708. This is 1732. Okay.
Now, lost me page 53.
Tax payable and paid.
So, lost me the output tax, total tax payable is mentioned below.
Hmm.
Now, tax paid within the prescribed time they mentioned. You lost it.
Date on or date on or before.
Tax paid within the prescribed time.
Here it page 54. This is
53,
W
you lost me first take
53. 53. Okay.
Now, total tax payable mentioned below, second column.
Hmm.
Now, you lost me
Total tax payable, yes. Tax paid
paid
within prescribed period.
prescribed time. This is
Hmm.
balance tax due.
Hmm.
Now, they have added the interest on that one. Thereafter, you also total tax payable, tax plus interest they have said.
Hmm.
Thereafter, you also total tax payable, amount of tax
Paid
subsequently
subsequently.
paid.
Hmm.
That's the amount is mentioned.
Hmm.
You know, at the time of assessment,
Hmm.
no tax was payable. As my learned friend said, they have calculated the interest on the basis that the tax was due in 1999 and amount was paid subsequently. This was clear. You will also find it page 64.
Okay.
April 97,
Hmm.
amount so and so. Have you also got in below?
Uh-huh.
Due on or before, paid on velocity. The dates are there.
Hmm.
Up to 2005.
So by March 98,
For 23, 2005, the amount was cleared.
23/3/2005, it was cleared.
And total amount you will also see. Thereafter, there is no amount of tax payable.
Hmm.
They have only calculated the interest in the right hand column. At page 54.
Yes.
So the tax was not there. Now the assessment was made, my lord. You'll also find on 1/10/2015.
1/10/2015.
So on 1/10/2015,
Hmm.
there was no tax demand. And the demand was only on account of interest.
Hmm.
And this honorable court on interpretation section 22 of the Act has held that if there is no tax demand prior to issuance of the demand notice,
Hmm.
the interest will not be there. So
Okay.
also may again,
So therefore, now their ground is this, if I could properly understand, that they have now calculated those periods where there was delay, 53 days that in payment of tax. Now question is, they have not issued demand at that point of time when there was a
that
delay.
was set aside.
That was set aside.
That was set aside.
Hmm.
And your lordship, if your lordship may, I will satisfy your lordship
Hmm.
section 22 also again,
Yes.
because by duty to satisfy
More
also,
particularly in this court.
when a 22, although they have been quoted,
Isn't it, Mr. Gogoi?
I must satisfy your lordship
Hmm.
on the basis of section 22
Okay.
at page 1, my lord.
Page 1 of the compilation.
Compilation.
Okay. Okay.
Well, first of all, subsection 1.
Okay.
Where a dealer fails to pay the full amount of tax payable by him in accordance with the statement furnished by him
Hmm.
under subsection 2 of section 16, or the return furnished by him under subsection 3 of section 16 as may be applicable to him on or before the due date or date on which such payment were due to be paid under subsection 1 of section, he shall be liable to pay interest. So when he will be liable to pay interest, what? If the person either fails to pay the tax as per the statement which he has submitted, or as per the return submitted by him, as per the return and statement, whatever tax was due was paid.
Yes.
So the question of application of subsection 1 does not arise.
Yes.
Assuming without,
Hmm.
as per the return, my turnover is 1,000.
Hmm.
But subsequently it is found to be 1,500.
Hmm.
Subsection 1 will not be applicable because it provides that interest will be payable only if the dealer has not paid the taxes as per the statement submitted by him or the return furnished by him. So one has to pay the taxes as per the return. In case the interest maybe the interest is 1. Now we come to 2 million.
So this is a concept that when you have filed a return that this is my income, and therefore you have paid it. Then there is a disparity
Later on,
under subsection 1, it cannot be levied.
Right.
Interest cannot be levied.
it is very clear.
Hmm.
Now document 2. Where the dealer fails to make payment of the full amount of tax due on the basis of the notice of demand issued under subsection 1 of section 25. Where a dealer fails to make payment of the full amount of tax due on the basis of notice demand issued under section 1 of section 25 on or before the date fixed for the payment under section 2 of that section, he shall pay simple interest at the rate of 2% for each month on so much of the such debt as remains unpaid from the first day of the month next following the aforesaid due date up to the month. What it says here,
Hmm.
that if I fail to pay the tax as per the notice of demand, issued on substance 125 on or before the date fixed for its payment under I will be liable to make the payment from your Lordship, he shall pay simple interest at the rate of 2% for each month on so much of the tax as remains unpaid from the first day of the month next following the state due date up to the month point. In the notice of demand, 30 days time is given for making payment of.
Yes.
If I fail to make payment of the tax amount as per the notice of demand,
Now,
interest,
under what circumstances notice of demand can be issued under section
assessment, my lord,
section 25? So this is, suppose you first stage is interest payable by dealer when you declare and pay no interest. Thereafter, they make an assessment. They found that no, your declaration
Assessment
is not correct. This should be the actual assessment. Accordingly, they will demand you that please pay this tax. If you don't pay within a period of so there will be a tax interest lapse for different period.
interest from when? After expiry of the 30 days period from the notice of demand.
Hmm.
It doesn't say that you will be liable to pay interest
From
from
the
very beginning.
not
That provision is-
from the date of return.
that is not, that provision is not there.
Hmm.
So subsection 2 is also not applicable
Hmm.
in the present case. Now, 3 your Lordship, see,
Hmm.
where the amount of tax referred to in subsection 2 exceeds by 10% or more of the amount of tax payable by him in accordance with the statement furnished by him under subsection 2 of section 16, or the return furnished by in section 3 of section 16, or where no statement of return has been furnished, the dealer shall pay in addition to the interest payable by him 1 or 2 simple interest as 0% for each month of such excess, or as the case may be, on the entire amount of tax referred to in section 2 from the first day of the month immediately following the due date for payment of tax for the period for which the assessment is paid to June. Now, what it says, my lord,
This
that
is now again comes under exceeding certain percent.
if it exceeds more than 10%,
Hmm.
here there is not a single paisa payable. Where is the question of section 3 applicable?
When according to when subsection 2 is not applicable, when this question of subsection 3 will come.
And subsection 3 specifically says, my lord,
Hmm.
that the tax referred to in subsection 2 exceeds by 10%. So subsection 2 is a notice of demand. Now notice of demand is nil. So where is the question of it exceeding 10% of the statement return? So subsection 3 is also not applicable. Now,
Because demand is not related to payment of tax.
my lord, in certain provisions have taken subsection payment. In this case, there is no provision that the period from when it became and the period from
Yes,
it made assessment. That interest is there, that provision is not there. Payment. Now, things were not there. Or they were things to be charged. That this is charged. Things was not there. But therefore, they have not provided for that the assessment, if make the assessment tax will be there, then it will be from the due date. That provision is not there. The contention was that if that type of provision is not there in the Act, 1, 2, and 3, and you also aware tax and interest can only be charged
Under statute.
provision.
Provision.
It has to be kept very strictly. On the strict interpretation of 1, 2, and 3, if I don't fall in it, then I should also they are saying that we are losing equity has no role to play in the taxing statute. Either you fall or you don't fall. Since I don't fall in it, the question of any equity or loss of revenue will not come at all. Now, if you also wants to look into section 22 after amendment,
Okay. Yes.
requisite 1.
Hmm.
If any dealer does not pay the full amount of tax payable by him, that is tax by the date on which it was due, as per the province act, simple interest so and so. Now here, as per the return and as per the statement has been deleted. In subsection 1 of prior to allotment defined, tax payable as per the statement and as per the return.
Hmm.
Now that has been deleted, said
Here, what is due? Because
What is
that
due?
if determination is made that it was some due is something, but you have declared something, then it will be taxable.
because payable
That is, pay interest can be levied.
by the.
In earlier case,
It's
to
not
that extent, you have declared and you have paid
as
to
per the
within a
return
period,
whatever was
not
there.
not be paid.
Now will also I may read particular. Simple interest as is showing so per month from the first day of the month next following the state date shall be payable by an amount by which the tax paid is any by the appointed date so short of the tax payable. So what is the value? It is completely different. Now will also see where interest payable by the dealer after the following provision is not paid in full, the assessment authority shall determine the payable by him for the right. If by result of the posting of the tax, the amount of tax payable by the dealer under the following provision shall correspondingly reduce or enhance as the case may be, the tax shall be payable. So if by virtue of the proceeding, that is assessment, the tax is enhanced or reduced, the tax will be accordingly payable. So this is the amended provision of section 22 of the Act. Now, if you also compare this provision with the pre-amended provision,
Yes.
it will be absolutely clear.
Earlier it was payable to him in accordance with the statement furnished by him under subsection
Or return furnished by him.
or return furnished by him.
as
So
per
payment was responsibility to make the payment as per his return or assessment
the or the statement.
statement, return or the statement. However, in subsequently it has been deleted by say that payable. Payable in mean payable in terms of the act.
And it says to see that if it is enhanced and reduced, then also he will have to pay interest,
Yes.
which is not there. And 2 says that if the tax is payable as per the demand note, and the tax is not paid in time prescribed, then interest will be leviable from the expiry of that period. In my case, when the demand note is no tax demand is there, the subsection 2 of section 22 pre-amended will not be applicable at all.
Not applicable.
So this honorable court correctly interpreted section 22. You'll also find section 22 has been reproduced. At page 49. And I will take you towards one paragraph only without all further, page 50. Page 50 below, second paragraph.
Yes.
Subsection 1 of section 22 deals with the situation where the SSC does not pay the tax as per the returns, or if there is any deficit, payment of the tax interest on deficit amount becomes payable as per the return law. Subsection 2 deals with the situation where after the assessment it is found that the demand notice is issued, and if there is any deficit payment which falls short of the amount claimed in the notice, the interest becomes payable. Subsection 3 deals with the situation where the assessing authority finds that the turnover stated in the return found to be incorrect and the amount mentioned in the demand notice succeeding the assessment is more than 10% of the interest payable. Who will be only when there is a demand notice, the demand is more than 10%. Because it refers to subsection 2.
Okay.
Now they are only referring to section 3. Section 3, they are failing to understand a lot that it says that with the statement furnished by him, section 2 of section 16, or the return furnished by him so, or where the no assessment, where the amount referred to in subsection 2 That is the demand notice. So if the demand notice is nil, where is the question of application of section 3 of 322 of the Act?
Your case is that the assessment made by us, tax is paid. Okay,
Prior to that,
prior to that has been paid. There was no demand after your assessment on shortage of tax. When there is no demand, therefore, subsequently, it cannot be that that in terms of section 2 and subsection 2 and 3 shall not be
in
applicable.
short, I must say, there was no provision in the Act
Act.
that the interest will be debatable from the period it became due to the period
That it-
of the assessment.
That's it.
There is no
No
provision,
problem.
which has been incorporated
In the
after amendment. And as such, since there was no provision at all, thereby the question of levy of the interest does not arise. And the assessing authority and the appellate authority, in fact, in my humble submission, they have committed contempt by sitting over the judgment of this honorable court and re-examining section 22, contrary to what has been held by the honorable court in the division bench judgment. And I given the judgment, my lord, in the compilation. Page 2, given part of page 10 and 11. Page 10, last slide.
It's 10. Yes.
The last time, while acting as a passage, not for capacity, they are bound by the law and not by the administrative actions, opinions, verification of purpose. Law is what declared by the court and the high court, to which it is for the court and the high court to declare what is such a particular provision of the statute say, and not for the executive. Of course, the parliament is able. So for this court to say that what section 22 say, not for the assessing authority, the appellate authority. Now we also see page 13 at the 11th part at page 15. Para 8, Miller. The third line. By that order, the respondent authority virtually refused to carry out the directions which the superior tribunal has given to him in exercise of the appellate power in respect of order of assessment made by him. Such refusal in effect denial of justice and its furtherance destructive of one of the basic principles of the administration of justice best as it is in the country on a hierarchy of the court. If a subordinate tribunal refuses to carry out directions given to him by a separate tribunal in exercise of the appellate power, the result will be chaos in the administration of justice, and we have indeed found it very difficult to appreciate the process of reasoning by which the learned judicial commissioner found condemning the respondents for refusing to carry out the directions of the superior court, yet held that no manifest injustice resulted from refusal. Must remember that the order of tribunal dated so was not under challenge before the judicial commissioner. That order has become final and binding on the parties, and the respondent could not question it by weight. As a matter of fact, the Commissioner of Income Tax had made an application for a reference, which application was withdrawn. The Judicial Commissioner was not sitting in appeal over the tribunal, and we do not think that in the circumstances of this case, it was open to him to say that the order of tribunal was wrong, and therefore there was no injustice in discarding that order. As we have here also, he is saying the same thing that you misrepresented. Now, also see page 17. Para 7.
There are 7.
Right.
Of
Para
Page-
17, so it starts from page 17.
17 years. Para 17.
Seven.
Para 7. The question involved.
The question involved whether a person can ask the Commissioner of Income Tax to delete the decision of the High Court on the basis which reference has been another decision of the count that such a decision is not correct for each purpose. Not difficult to state that you can find it ground review, but in the present case, we are not concerned with the question of review as commonly understood. It's true, the decision is reference made by not followed by the full bench, the law declared by the bench. Not so the question is whether the basis of bench has signal compelled to change the judgment under the basis of the extent which is stated below. Thus, he made clear that as to the reference he made answer, the tribunal had to pass orders and appeal on the basis of which the reference was put up. The clear that once the reference has been decided, the tribunal had no other go but to decide the question.
Okay.
They have no other alternative. I will also see page 20.
Paragraph.
Page 23, Miller. Part at page, there are 66, 62, Miller. At page 40,
Page 40,
my lord.
page 62.
My lord.
It is well
Page
settled.
40, page 40, paragraph.
Okay, it is well settled.
It is well settled that the judgments of this court are binding on all the authorities in Article 142 in not offend to any authority to ignore the binding judgment of the court on the ground that the full facts had not been placed before the court and or the judgment of this court in the earlier proceeding had only collaterally or incidentally decided the issue raised in the proposed notice. Such an attempt to belittle the judgment and the order of the court, to say the less, is plainly perverse and amounts to gross contempt of court. What the appellate authority has said, exactly what the Supreme Court has condemned. Other judgments also, my lord, I have got this
Okay.
line. But this settled, my lord, that he cannot sit over the judgment of this honorable court and say that this honorable court has misinterpreted section 22 of the act. And I, my lord, also explained to you, lordship, that for section 22, this honorable court was absolutely correct. So in my humble submission, my lord, my London friend is very correct. If the matter would have been after the amendment of 20, perhaps it would have been tenable. But since the provision was not there at all in 22, it be done.
Gogoi.
In this regard, we have filed an affidavit today. But before that, if your lordship may kindly see the appellate order at page relevant part, I will take on the page
We are taking up this item, 1708.
178, page 67.
Yes.
It is page 66,
66.
para 8.
Hmm.
At the time of hearing, the learned OA, that is the assessing officer, had pleaded that it is indeed a fact that the Honorable Guwahati High Court reverted back the case to the assessing officer for passing press assessment order. As in the earlier order, it was not clear as to whether there was any tax liability preceding the demand notice. As per direction of the Honorable Guwahati High Court, assessing officer duly verified the case and passed an assessment order wherein it clearly mentioned the logic behind levy of interest on the basis of statutory provision of the AGST Act 1950. It was stated by the learned
You.
assessing officer that though the amount of tax payable was due on 30/3/1996, but the amount was paid on 5/6/2002. As per section, this has been quoted. As a result, demand of so and so was raised against the petition. He also pleaded that the appellant has misconstrued the provision of the Act. The section 16(1) prescribes that tax payable under the Act shall be paid in such manner and at such intervals as may be prescribed. Then, subsection 2 prescribes that any payment of tax under subsection 1 shall be accompanied by a statement in the prescribed form of turnover of sale or of purchase in respect of which the tax. The Lordship will kindly see my lord before I go further the provision of tax.
Yes.
This page 98.
Page 98.
15(1) says, tax payable under this act shall be paid in such manner and at such intervals as may be prescribed, provided that different intervals may be prescribed for different categories of. So, my lord, there is a period by which, my lord, they are to pay the tax. My lord. Say, my lord, 1 monthly, quarterly, half-yearly, or annually. Next 2 says, any payment of tax made under subsection 1 shall be accompanied by a statement in the prescribed form of the turnover of state or of purchases in respect of which the tax. So, my lord, this statement part is also very clear. Yeah, further. Para 10. Therefore, the AO has vehemently opposed the contention of the petitioner. It is also pointed out by the AO that the correlation of the point A amount of tax payable and B by a statement in the prescribed form has thoroughly been overlooked by the petitioner in the effort to extract undue favor, keeping the forums in dark indecision.
No, now let us have one clarification.
Right.
This is an issue that they have not filed in proper form or in terms of 16(1). It was not an issue at all
That
in
was not,
either of the proceeding.
but that
What was the
clear.
issue? Moment this is not an issue in terms of subsection 1 of section 22, when somebody assess maybe in a wrong format, not following 16(1), he assess or gives a statement and makes a payment of tax.
Well-
In terms of the earlier act, if that is wrong and assessment is made subsequently, there cannot be any interest from the period of his own assessment to the assessment by the assessing officer. When interest can be levied is from 2 occasions, subsection 2 and subsection 3. Subsection 2 and 3 is assessment is made and you are asked
Demand
to
notice.
demand is given, then only. So therefore, therefore cannot be a demand for payment of less tax in terms of subsection 1 of section 22, where there is question of payment of interest for wrong return or wrong payment or less payment or delayed payment in terms of section 21. That has not been yes,
But that part probably was, my lord, missed out.
maybe missed out.
But one thing, my lord, while the matter went to the division, to the apex court, the honorable court matter held that we will be at liberty, my lord, to this lottery mechanism.
Liberty to as per the statute.
Interest, my lord.
As per the
Specific-
statute.
They
Now
said,
the
my lord, would
statute
be
is
liable to
interpreted
pay
in the
this-
same context by a division bench in our case, in relating to the same parties. Had it been in a different state, different case, you may say that no, this is the not
No,
this
but also
division
we
bench.
see, my lord, the division bench considered, my lord, total, my lord, 6 cases. 2 was allowed.
Hmm.
94,
And
95.
other is two was allowed. The other petitions were not allowed on the ground that the particulars as regards these specific things was not there. So now it was relegated that please determine these 2 facts and decide.
So, may I read, my lord, para 9 of the page
Okay.
59 of the compelling
Page 59.
of the division bench.
Okay.
However, in respect of WPC number 2020, the demand notices are issued for payment of balance of interest.
Page 59.
59.
Paragraph
9.
just a minute. We are on 1708.
No, my lord, of the compelling.
Okay, of the compilation. Paragraph
Paragraph, my lord, page 59.
page 15.
Para 6, the last para of para 6. In the case in hand, or may I read, my lord, entire 6, my lord. Subsection 1 of section 22 deals with the situation where the SSC does not pay the tax as per the return, or if there is any deficit payment of tax, interest on deficit amount becomes payable. Subsection 2 deals with the situation where after assessment, if it is found that the demand notice is issued and if there is any deficit payment which falls short of the amount claimed in the notice, the interest becomes payable. Subsection 3 deals with the situation where the assessing authority
finds that the turnover stated in the return sheet is found to be incorrect and the amount mentioned in the demand notice succeeding the assessment is more than 10% term it should be, the interest becomes payable. In the case in hand, the earlier assessment orders and demand notice passed were set aside by the Supreme Court with a direction for de novo assessment, and after the de novo assessment, it is found that there is nil demand for the assessment yet. Therefore, the question of payment of interest for nil demand does not arise. In view of the above, this to read petition in relation to the for the financial year assessment year 94, 95, 96, 97. However, in respect of the other four, the demand notices are issued for payment of balance of interest.
Just a minute.
It is not clear whether there was any tax liability preceding the demand notices, whether the difference of liability is more than 10% between the returns and the demand notice. In this regard, the Superintendent of Taxes is directed to verify and pass fresh orders in accordance with the law under Section 22 of the Assam General Sales Tax Act.
Okay.
Accordingly, so
Now, where is your finding that
yes, that
SCC does not pay as per the return, or there was a deficit payment of tax?
well, in terms of the court order, that what you will find in 1708 page 53.
Yes,
53.
they have been asked to do a specific inquiry, because this court in that appellate jurisdiction or judicial review would not do that exactly.
They that the Honorable Court, the query was, the point which was referred to the authorities. to
Where is
verify.
that? Where is that order?
It is at page 53.
Page 53 of the
1708.
1708. Yes.
At the top, the chart is there. Demand as per original assessment, amount, interest, total payable amount paid, balance due is so and so. Demand after order of the Supreme Court. The total payable amount is so and so, amount paid is so and so. So, so far as the tax liability is concerned, it is nil. That part, we are admitting, that part they have paid. But while making that payment, there was a delay. That's the.
We understand. Your case is that
Only on that point, this order was passed.
there was a demand that has been paid. So therefore, when that demand was not paid, therefore, in terms of Section 3, you have a right to impose tax.
Interest.
Okay. Now, when
may-
this demand was issued?
The demand, here, according to the, may I read the, para immediately next to the chart. Therefore, from the above, it is evident that though the amount of rupees 2 lakhs was C1 34,1998. So we will see the figure 2206. It was C1 34,1998 and the amount was paid on 5/6/2000 and subsequent. As per Section 22(3) of the SGST Act 1993, but the amount of tax referred to in subsection 2 exceeds the 10% or more, the amount of tax payable by him in accordance with the statement furnished by him under subsection 2 of the Section 16, or return furnished by him under subsection 3 of Section 16, or where no such statement or return has been furnished, the dealer will pay in addition to any interest payable by him under subsection 1 of or section 2, simple interest at the rate of 2% for each month on such success, on such excess as the case may be, on the entire amount of tax referred to in subsection from the first day of the month immediately following the due date for payment of tax for period for which the assessment is made, up to the end of the month in which the assessment is made, up to the month immediately.
That we understand, but where was the demand notice original? Because see, the payment of interest should start from the, even if we subsection 2 or section 3, from the date of demand, isn't it? Not from the date of return. So admittedly, whatever return they have filed is filed. Okay, they have paid their tax. There is no dispute on that. Now, after your assessment, you say that there was a demand
Yes.
that they should pay some excess tax.
Right.
Okay. Now, according to you, those taxes were paid at the later stage. It has become due on 31/5/97, paid on 13/11/2001. Okay.
Well, the demand, well, which was raised for this particular amount in 1998 or so at that period. Something with where is that?
So therefore, my query is, you can demand an interest when there is a tax due.
Tax, yes.
Tax due.
Well.
Now, on the date of, according to Dr. Saraf, on the date of issuance of demand,
Right.
there was no due.
At all.
No due at all. When there is no due at all, you cannot demand interest, because the interest is on for the reason that we have demanded you to pay this tax, you have wrongly calculated this is due, you have not paid, and therefore you are liable to pay interest. Now, on the date of demand, admittedly there was no due, but there was a delayed payment. That delayed payment.
What I'm saying is, madam, the very first statement I made that, madam, the interest not on the demand of tax, demand due, madam. It is on the delayed payment. What?
Understand?
So
Delayed payment should be from delay from which date?
Lordship will see,
Delay
my lord,
from the
20 to 1 again, my lord, from my perspective, my lord,
okay,
20
okay,
to 1.
okay,
May I repeat page 1 of the complaint?
okay. No, no, let us understand. We have not taken any view.
22 was, my lord, this is the provision prior to amendment. 16 was there, my lord, at the time.
16 was there, no doubt on that.
Yeah. So 16 says that, my lord, tax payable under this act shall be paid in such manner and such interval as may be prescribed. 2 says, any payment of tax made under subsection 1 shall be accompanied by a statement in the prescribed form. So whoever my lord makes the payment within the particular period, say, in an interval, will have to be through a statement in the prescribed form. Now 16.3 says, every registered dealer and every dealer who may be required so to do by the assessing officer by notice. So 3 says about notice. Issued in the prescribed manner shall furnish in addition to the statement or statements, if any, furnished under subsection 2, an annual return in the prescribed form, accompanied by such statement as may be prescribed within such time as may be prescribed, provided that the state government may by rule pay.
That is fine. Now, this query of this court is that we are assuming for a moment that they have violated 16 and 2 and return was not filed in terms of the 16.
No, not only filed, not paid.
Not paid.
Yes.
So, when not paid, you have a power to issue a notice under section 25 subsection 1. Okay?
Pilot.
Now, when you issue a notice under subsection 5 of 21 notice to demand that, see, you have assessed this and paid this tax. However, this is more. Your calculation is wrong. You are liable to pay this amount.
So, so far as the demand part is concerned, when it was raised in 2001, it has been put to challenge because it referred with thereafter we are directed to go for press that we have done again after challenge.
So that will come to later.
That part.
Now, what was the demand on that original date?
But in the meantime, they have paid the amount.
They have paid the amount.
There the lottery will have to.
So, but you have calculated tax for which period?
Well, this here in every case, the period is different.
Period is different. Period is different.
Why I'm
so
saying is,
their whole case is that when the tax will be liable to be paid from the date within a specific beyond a certain period, beyond certain period after the notice is given, demanding such tax. One situation is envisaged in subsection 2 of section 22 and other is subsection 3 of
section 22 1, my lord, amended. May I read it?
Yes, yes.
Where a dealer fails to pay the full amount of the tax payable by him in accordance with the statement furnished by him under subsection 2, of section 16 order return furnished by him under subsection 3 of section 16 as may be applicable to him on or before the date of date or date on which such payment are due to be paid under subsection 1 of that section. Here, my lord, it was due. He shall pay simple interest at the rate of 2% for each month on the amount of tax remaining so unpaid from the first day of the month next following the date on or before which such tax was payable up to the end of the month immediately preceding the month in which such amount is paid in full, or up to the end of the month immediately preceding the month in which an assessment is made, whichever is article.
So if it's
So it-
assuming that the
He has
tax
paid,
is
man.
payable under subsection
One,
1
one.
of section 22,
My lord.
that cannot exceed 2%, and the period is till assessment is made.
So it says, my lord,
Okay, a month immediately
First day
preceding
of
the
the
month
month
in which the
following the day of
assessment is
the-
made.
the tax was payable up to the end of the month immediately preceding the month in which the such amount is paid in full.
Okay.
He has paid it, man. So that's why we are saying, well, in 2002 he has paid. He was
Now
like-
assessment is made when? Assessment is made subsequently. On the date of assessment, he has paid the principal main tax.
So
Suppose we read, let us understand. Where a dealer fails to pay the full amount of tax payable him in accordance with the statement furnished by him under subsection 2 of section 16, okay,
Well,
or return furnished by him under subsection section 3 as may be applicable to him. So first condition is he fails to pay full amount of tax payable him as assessed by him under section 16.
well,
So first condition is that he has failed to pay his own assessment. Okay.
Right.
He shall pay simple interest at the rate of 2% so and so so and so. Till what period? Till the period when the assessment is made. See, I declared my income to be 100 rupees, but I do not pay tax.
Right.
I will have to pay an interest within the
my lord, assessment part, document see, my lord, last second line of subsection. May I read it, my lord?
Yes.
It says, after, my lord, subsection 1 of that section, he shall pay simple interest at the rate of 2% for each month on the amount of tax remaining so unpaid from the first day of the month next following the date on or before which such tax was payable up to the end of the month immediately preceding the month in which such amount is paid in full. This is one part, madam.
Okay, this is
Now
one.
again, or up to the end of the month immediately preceding the month in which an assessment is made, whichever is earlier.
Very
So there
good.
is two situations.
Two situation. No problem on that. No problem on that. Problem is that I assess my income to be 100 rupees.
Yes.
Myself under section 16. But I do not pay.
Yes.
But I do not pay.
Yes.
That comes under a situation under subsection 1 of subsection 22.
Well.
There two situations are there. Payment of tax to 2% either way.
Sure.
And that relates to why that assessment is given. Because when assessment is made, then the provision of demand under subsection 2 and 3 will come. Okay. So I declare myself, this is fine. Now come to the when thereafter, suppose I paid the tax or not paid the tax, I am liable to pay 2%. Now second sequence comes when your assessing officer assesses that this is the assessment. And it finds that no, his income is more than 200. Though he himself declares as 100 rupees, his income is more than 200. On that finding, the authority will give a demand notice.
Yes.
That please, we have assessed it, your income is 100 rupees more.
Right.
So you have already paid 100 rupees or interest. This remaining 100 rupees, you pay tax on this. Mr. Saraf's case is that when I have paid my own assessment, you can claim interest on your demand from the date when you make a demand. When the date on which you made a demand. On that date, there was admittedly no principal was to be paid. So the principle is this, according to me, that a person should be put into a notice. Let's say this is your excess amount, please pay. When he is not paying that tax, then only the penalty by way of interest will come. Here he paid the principal. So in terms of section 2, according to Dr. Saraf, is not applicable. Am I understanding something? Hard. Devi. Saraf after Bihu.
But one thing I may perceive
Ah.
permit me.
Yes.
Subsection 3 to the Constitution.
Ah.
Where the amount of tax deferred to Section 2 exceeds by 10% or more of the tax equal by according to the by if the difference of the tax is less than 10%, interest is not there at all. So it says only if it exceeds by 10%, then
10% compared to your self-declaration made under subsection 1 of section
on the
22.
basis of Section 2,
Hmm.
if the tax demand is there as per demand notice, and that is more than 10%, then only interest will be able, assuming more of the demand notice is there, and the difference is only 5%. Interest will not be there. So subsection 3 only says that the difference between the demand notice and the tax must be more than 10%. In my case, the demand notice, the tax is nil. He will not be applicable at all. The entire exercise, when they realize, they amended. What can be done?
Wisely amended.
It should have been amended.
But my affidavit,
Ah.
internal page 77.
Page 77.
And by quoting the provisions of section 22,
Hmm.
the confirmation of subpara act.
Ah.
Here, there is one final correction in the third line,
Hmm.
page 77.
Hmm.
Subsection 3 of section 22, not 33.
Where? Put a
In the-
subsection 3 of section 16.
Page 77.
Ah.
Subsection 3 of section 22, third line.
Third, that's the second line.
Page
By,
77.
it starts with by him under subsection 2 of section 16.
No, the second para. This is a
Second para.
quotation of the
Okay.
further,
Subsection, further,
third line section 22, not 30.
section 20.
May I read this part? These are 10 actually.
Okay. You do one thing, Mr. You just correct it and have an initial. Huh?
Right.
Or you have file in.
No, we have filed. I will make it correct.
Okay. Okay.
You make only record.
Okay, I'll record.
May I read this part?
Yes.
Further, the deponent may state that upon plain reading of the provisions of section 22, it can be envisaged that the subsection 3 of section 22 provides for levy of interest on the shortfall of tax payable for a period prior to an assessment. Thus, shortfall in tax has to be considered as tax payable for such tax period, and accordingly, interest is payable for the period from the due date of payment of such tax till the end of the month prior to such quantification. as
Assessment.
The shortfall in tax payable under subsection 22(3) refers to the difference between the tax quantified on the assessment, applying correct position of law, and the tax due as per the self-assessment of tax by the dealer. Additionally, for the purpose of levy of interest under subsection 22(3), the difference between the full amount of tax due as per the demand notice and the admitted tax must be 10% or more. Additionally, subsection 3 has enjoined the liability to pay interest on such amount of tax which has not been paid as per return with reference to the assessed tax. C. That to understand the interest implication of the dealer IOCL for the year 95, 96, 98, 99, it is required to have a look at the assessment made for the said period. Here, the first column is regarding the year, assessment year. Tax as per the original order. In the next page. So these are the amounts, my lord. Additional tax as per the order of the Supreme Court of India is this, my lord. Tax paid with due date within due date is my lord 2243.20. Tax paid after due date, it is 4774.43. Interest levied on the delayed payment is 20. The deponent for the to submit that while framing the
Now, suppose there is a delayed payment,
something was paid, but the amount was paid.
but who has determined that this is whatever you have? Suppose somebody pays, liable to be pays taxes 2%, assuming for a moment that this is my assessment. I have paid in a belatedly I have paid this amount. Now 2% interest is there, assuming for a moment under subsection 1. A demand is not required. Suppose man is not aware. First case, he will be liable to pay because he himself knows that this is my return, I have not paid. This is not your case. Your case is not under subsection 1 of section 22 that he assessed this amount but not paid. So therefore, then only also this is 2%. When section 2 comes, you will have to make an assessment and see that there is a difference. What have been assessed by yourself is lesser than what we have assessed. So therefore, pay this.
The next paragraph,
Okay.
page 79.
Hmm.
The deponent for the submit that while framing the assessment order, the assessing authority gave credit the already paid amount by IOCL in lump sum as per memorandum of understanding. The interest levied was for the delayed payment of tax on the value addition part of BRPL product, which was not paid originally but after due date of payment and is as per the statutory provision of this chapter. That the interpretation of the statutory provision pre-amendment section 22 of the GST Act and the thorough examination of the assessment orders and the clear instruction of the Honorable Supreme Court of India clarifies that the dealer IOCL is required to pay interest on the taxes on the value addition of BRPL product, that the same has been credited by assessing authority from the payments made by IOCL on different dates. The interest charged as per the statute is on the account of compensation for loss occasioned to the revenue due to delay in payment of the excise. It is a settled principle of law that interest claims is unpaid tax is compensatory is correct. Thus, it is further evident that the petitioner was aware of the provisions of the statute. And
Basically, you have more or less incorporated the question, your points of arguments. Okay.
maybe taken into
Yes. Hmm.
Also, statements are there, but the return with a copy to my desk. But what I have
Yes. Yes.
support of that.
Yes.
If you type 54 days.
Okay. Let us do one thing. When?
So document reject the judgment. So they
Why should I delay this the judgment?
so you reject the judgment. I will not they have not commit. I will not be.
No. We'll reserve. Almost we have reserved. Give the exchange the copies. I want.
I will not submit it. You will not submit.
No. It is
Instead of you will
okay. Okay. Hard save it. Give the judgment.
I do.
Just a minute. That assessment order of 2001 is part of this writ petition.
That was set aside.
No, said was this is not part of.
those
No?
documents are not there. That's why my lord, otherwise
Because
it's more easier to understand.
proceedings below,
Hmm.
the court has held that once it has been set aside,
Hmm.
that no longer remains. That is there in the order itself.
Now, just one issue. So SLP was preferred, then SLP was,
Dismissed.
the SLP was dismissed.
No, prior to that, my lord, SLP was there. Twice, it is
SLP,
particular
first SLP,
Yes.
I found that I went to judgment of,
2007 or
That is SLP 6619 of 2001.
that is a different period, that's the principal portion you have to pay.
Yes.
Prior to that, in fact, the judgment was, amount was paid on the basis of memorandum.
So there was an assessment on 18/7/2001
That was set aside
that was set aside
in the, by the Supreme Court.
by the Supreme Court. Where is that judgment?
For that, I've given the Supreme Court judgment.
That is what I want
It's
to.
not there in the complaint.
Separately, I've given.
Oh, that.
No, it's not a reported.
Reported it.
Reported. Which one is this? Uh.
2007, 11, and 16.
Just a minute, huh? I've kept it. That's why I want to. 2007.
2007, 11, and 16. Separately, it was given.
To file a Kumal because I was reading the 2007.
11 and 16.
Just a minute.
I give me another copy.
Because we are. There are extra copies. Let me see. The affidavit from Parva. Give it to Gopal. 2007 11 SC 704.
693. So given extra copy.
Okay. This is important because this will
Yes.
give the back everything.
Letter was emptied back to paragraph 20.
Paragraph
20.
20. Now, what was done thereafter?
So thereafter they passed the order. They passed the order.
Which was challenged in the
Division bench.
division. This were this orders similar to this writ petition. Okay, where
In fact, my lord, division bench order is part of the every. It has
It is common
Ah,
for the
that is there. Subsequent to this, the order passed was challenged before the
But at that time, my lord, division bench. was
division
taken up
ensured
with
that the division bench.
it went-
Then that division bench went up to the Supreme Court.
in fact in my petition.
Ah.
I have referred to every matter that how it was.
Okay.
Facts
First,
are narrated.
facts are narrated.
Everything.
That is what facts are narrated. I can rely on these
Yes,
facts
Not
huh,
everything.
yes.
Everything.
for details.
Only,
Okay.
my lord,
That
the,
now I have found that list of dates. Everything is given.
yes.
Only
You
question.
don't dispute the facts, Mr. Gogoi.
That's
Okay.
on record.
Okay.
That is in affidavit.
I think we have given from beginning without.
Ah.
That is single judge, division bench, court, attendance, everything we have done.
Okay, what judgment you want to give? Give us you give. Okay, within
3
what
days.
was- 3 days. Save it.
I am highly obliged.
Obliged.
The first step, better, but I argued for.
First tax matter I am hearing. Okay, kata. These are related to item number 4, 5, 6, and 7. Mr. Sarab, can I have a, any copy Xerox of, some, which is, 1993 Act or relevant,
Document keep
but it will take some time after
Yes, yes.
Bihu. We'll get it after Bihu.
5 books are there in the front.
Okay, keep it in the, but thereafter return. It will be after Bihu.
I'll-
There are two more text messages.
Huh?
Can you agree, can it be
It's 2014 matter only. I mean.
Next week what? This, which matter?
35, 30? In fact, my records were called for, my lord, in fact, the part hard. So Lord Civil here is short, my lord.
35 and 36.
Yeah, I've got the record of one case that will cover both.
Today,
At the different time.
will-
I have no problem, but today too many matters are
Yeah.
there.
There is one matter already, the hearing your started, that the medical.
Huh. That also you have given the, this written arguments.
The other side has given return.
Given written-
That may not require judge.
That written is given, that also will make it CAB and it will go up. This will be after vacation.
After vacation, but that is only for that ground we don't also kept it.
That has been given, so we'll make it CAB today.
Right.
Just remind me which are the orders.
So if you lost it 10 million, then we will not have to.
Huh?
We will not have to
Okay,
wait.
okay, this is the, give the item numbers.
I just supplementary list minute.
Supplement
Item number 57 to 60 million.
57 to 60. CAB, huh? For Kohima. Page 14, yes.
Yes, ma'am. I am reading this is material. The learned departmental council to obtain instruction and apprise this court has to whether by freezing its e-portal account, the petitioner has been prevented from withdrawing its dues relating to the other contractual work. If so, the remedy thereof, if any.
Then,
That next page, your lord. The relevant portion is at page 16, Mike. Mr. M.K. Chaudhary, learned senior counsel, together with his succeeding counsel, or the respondent through video conferencing has submitted that in respect of the query of the court as made white order dated 6/10/2020, he has received instructions from the respondent to the following effect. By freezing of the e-portal account of the contact, Mr. Surya Krishna is private.
yes, I have read that.
Yes. Despite that, my lord, they are withholding my security money relating to the other. Now they are saying that this system is not allowed. They have given this
No,
under.
where is the contempt? This is an instruction, any order passed that they should be done anything.
This is like a undertaking, my lord. And undertaking a violation of undertaking is also amounted to the contempt of court. This is in the form of undertaking, not a simple instruction. My lord.
Your or contempt is against which order?
Against this order, my lord. This is a this order. This is a undertaking given by them before this honorable court, which has been violated by them.
Okay, then,
And my lord, some correspondence exchange between the parties, my lord.
okay,
Despite
come
the-
to the other requisition first, we'll come to contempt later.
main writ petition, my lord, I have challenged the termination of the contract, legality and validity of the termination of the. And the your lordship may take this a writ petition 6372 of 2021.
What is 3900? Let us go one by one by age.
First, my lord, first, my lord, 3900.
3900.
Yes.
What is 3900?
In this matter, my lord, this I have challenged this termination letter, my lord.
Okay, then
Thereafter, they issued another letter for blacklisting me, putting on the
so
holy
termination of the contract.
contract.
So you propose to say that we will determine whether termination is bad or good
Yes.
in a judicial review.
Yes.
Okay. Where is the impugn order?
At page 165. Yes. Page 160.
160.
Yes, my. This termination letter is in 14 pages. So many clauses they have quoted in this. My main ground, my lord, this termination of contract is unlawful.
This termination of contract is
Unlawful.
unlawful.
Violative of the section 55 of the Indian contract. Because the contract expired on 29/12/2017. No extension was granted. And they directly terminated the contract on 11/12/2019 without granting any extension. When there is no contract, there is no question of termination. And in this respect, my lord, I am preferring one judgment of the Honorable Supreme Court. Here the time was not essential.
So if there is no contract, no termination, why should we judicially review it? No termination is no termination. It's
illegal.
invalid.
Their action is illegal. All this termination is illegal. So what is
This
the consequence?
termination is non-est.
No, no.
Non-est.
They cannot
There
forfeit.
is no contract.
Yes.
So why should we decide
They
this?
cannot forfeit by security deposit, performance guarantee.
So-
Nor can they withhold
So
by.
ultimately, what is your grievance is that by virtue of termination, my performance guarantee and others are
Dues are
Huh?
able to me that they should be
pay-
paid.
payable to you.
Yes.
So for that, you will have to go to your alternative remedy. You will not decide it. Okay, then your ground is termination is bad because
Yes. Contract expired on 29/12/2017.
the contract expired on
29/12/2017.
29/12/2017.
2017.
Okay.
And contract was terminated on 11/12/2019.
11.
12/2019.
And this forfeiture and all.
They issued the show cause notice prior to that matter.
Okay.
On 3/6/2019, they issued the show cause notice.
That is not really when your whole case is that my contract expired on 29/12/2017 and you have terminated a non-existent contract on 11/12/2019, which is in violation of section
55 of the Indian contract.
55 of the Indian Contract Act.
Because prior to the termination, no extension was granted by him. Although there is a clause for granting this.
Okay. So this is your case in 2000. Then what is the next case?
Next case,
Okay. So now we come to WPC 279/2020.
Yes.
Earlier was WPC 3900/2020.
sorry, my lord, this before that, this was earlier.
This was before that. That's why I'm asking.
Yes,
What was the earlier other case 279?
279.
just a minute, 279, 2020. And this is subsequent that we have noted is 3900. Okay, what is the case in 279, 2020?
Two 279, we have challenged this termination letter.
Huh?
Termination letter was challenged earlier.
So why to read petition?
Thereafter, they issued another order. After termination, they issued another order.
This is termination. Which order is under challenge in this termination? In 2020.
Same order.
Huh?
Same order.
How can there be two read petition maintainable?
No matter. Thereafter, some further orders were issued by.
So further orders are challenged under which read petition? In which read petition?
Yes, in this matter.
What is the challenge in 279? Tell us first.
279.
To set aside 17/9/2019. So cause 36/17/9. What is 79? Termination dated 11/12.
Local notice 79. Then thereafter, they put.
Just a minute, just a minute. You are not thoroughly prepared. You are not prepared.
For hearing for this, actually I am ready for this.
No, that cannot be. Contempt is the offshoot of all these cases.
But that is independent.
Your second case is so far relating to the order of risk and cost.
Yes.
Order of holiday listing for 3 years.
Yes.
Then what is the next case? Next case?
Next is 637.
What are these emails? Bank guarantee.
Bank guarantee already there for it.
I do not think, Mr. Ahmed, anything survives in this case.
I think that the value about well, less it is indicated by not. That matter is depending on that. If it is decided that the termination of the contract is illegal, I am entitled for all the relief. All the relief depend on that.
Okay. Any other writ petition?
Only
Okay, so whole case depends upon whether the termination is bad in terms of section
55 of
55 of the contractor. Since there is no extension. Yes, Mr. Chaudhary, what is your response?
My lord, my submission would be firstly, my lord, the termination order has been challenged in all these three. Fourth and the third petition, there are subsequent orders, which he says, my lord, still survive. And therefore, perhaps my lord, the first and second requisition, because my lord, the same order can be
First and second repetition become infractor.
infructuous, but
Like,
then
because everything can be, all the challenges made in the earlier two repetitions are subject matter
Yes.
of the third repetition.
Then-
Isn't it?
Yeah.
So that there is no meaning of keeping these first two repetitions.
Earlier two.
All are under challenge in the third
Yes.
repetition.
that is-
Including bank guarantee, risk and cost, then blacklisting,
Yes.
what you use something different.
Holiday.
Holiday list.
Holiday.
Holiday list, everything is under challenge in the third writ petition. Because you file a writ petition, there was no stay, they do another action. There was no stay, again you come and challenge everything, whatever earlier challenge. So first two writ petitions are gone. We'll close it. And then what is the third?
Third is my lord, one point is that.
And
challenging the
blacklisting also gone, 3 years is
2
over.
years past,
3 years
lord.
is over.
Over. Blacklisting is 3 years over.
So
What
he-
remains is that
whether the
termination is bad or good first, and whether in the given facts, we are not powerless, but in the given facts, whether this is a fit case where we should interfere with the termination of a contract. That's all.
Now, my lord, the only point here, sir, he may have other points, I don't know. That section 55 of the Contract Act.
Hmm.
That he's banking upon that point. Section 55, section 55 of the Contract Act will not be. It's mere perusal of the first, section 150. Here it is factually the case is that he was given a contract which he could not perform in time. We had given some extension, spite of the extension, he could not perform. And thereafter, after giving all the opportunities to him, the contract was terminated. Now, if your lordship kindly read section 55, effect of failure to perform at fixed time in contract in which time is essential. Where a party to a contract promises to do a certain thing at or before the specified time, or certain things at or before specified time, and fails to do any such thing or at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee. If
Hmm.
the intention of the parties was that time should be the essence of the contract. Now, a contract was given to him.
Now let us ask the question to Mr. Ahmed. So condition precedent is that the time is the essence of the contract. So that is to be determined by somebody else, not by us. That depends upon many facets. Time is the essence. It's a huge debatable issue. So this we cannot decide whether a term is the essence. Even if we agree that there may be a ground for that they have violated section contract is bad in terms of section termination in view of section 55. First determination is to be made that the time is the essence of the contract and these conditions are not fulfilled. That we cannot do in a judicial review.
To go to the
You go to the common. That you file an application that will be considered in terms litigating in a wrong.
excluded the period.
And my lord, perhaps your lordship may say that this may be excluded and he file an application that will be considered for exclusion.
Okay.
Instead of.
We'll say that it is, since it is a litigating it is court, this period may be, if a proper application is filed, be considered for
favorable.
exclusion of this period. That's all. Heard Mr. Ahmed, Learned Counsel for the petitioner, and Hussain, Hussain, Learned Counsel for the petitioner, also heard Mr. F.K. Choudhury, Learned Senior Counsel, assisted by Mr. M. Sharma for the
Respondent India report.
for Indian Oil Respondent, Indian Oil Corporation. These three three writ petitions are taken up together for disposal as agreed to by the London Council. The challenge made is this writ petition primarily is the termination of a contract. Primarily is an order issued by the respondent IOCL, whereby dated 11/12/2019, whereby the contract entered into between the petitioner on 21/12/2016 within bracket লিখিব work order reference capital লিখিব page 20 of this writ petition 6372/2021 capital IOA ODSO / LPG / 2 CSBP / WO. The other challenge pertains to certain decision of the IOCL relating to putting the petitioner under holiday list, encashing bank guarantee and non-payment of final bill for execution of the work and forfeiture of security deposit. The challenge to the termination is basically on the ground that the termination has been issued in violation of the issued in derogation of section 55 of the Indian Contract Act 1872 in as much as according to the petitioner time was that the contract period of contract expired on 29/12/2017 and the contract was terminated on 2019 11/12/2019 and therefore it is and therefore the time was essence of this contract. Not sufficient. Mr. It is the stand of the IOCL that time was the essence of the contract and therefore to determine whether time was an essence of the contract or not, it shall require a determination of disputed facts and therefore this court in exercise of such judicial review may not like to enter into such dispute where there is remedy of arbitration. Remedy is available. Just will remedy is available. Full stop. At this stage, Mr. Rahman, Learned Counsel submits that he may be allowed to withdraw these writ petitions with a liberty to approach the appropriate forum for determination and adjudication of the claim that has been raised in this batch of petitions. Such prayer has not been objected to by Mr. That being the position, the writ petition are that being the position, the writ is three writ petitions, huh? Three writ petitions stands closed on withdrawal with a liberty to the petitioner to approach the appropriate forum available under law to agitate its grievances. Full stop. As this matter is pending before this court, comma, if an appropriate application is filed
Section 14.
under section 14 of the Limitation Act, the appropriate forum may consider the same and exclude this period uh, in terms exclude this petition for for the purpose of limitation, and in the event such application is filed, then be considered. Accordingly, this writ petition, in view of the order passed in the contempt court litigo, in the connected writ petition, the contempt petition same IA same.
Regarding my lord, this contempt, liberty may be granted, file petition for recovery of this testimony relating to the other.
Okay. No, that's why I'm saying we have given liberty approved available under law. If I
For that, I will go for commercial suit. Here, in the other case, my lord, other contract, there is no this. Only they are
which writ petition then?
this contempt petition. If contempt petition, my lord, they are withholding.
ऊपर the main order देखो, it needless to say that any other dispute which can be agitated in before a writ court, the petitioner shall be at liberty to approach.
And the contempt case has to be closed.
Close, contempt close. In view of the order passed in the writ
Case
petition
number 356 of Clerical.
356 of 2021, contempt petition. IA 224 same in view of the order passed in WPC 3900/2020, contempt 1312. IAC 1312, that's yes. You have an interim order. You enjoy the interim order, isn't it? Yes, why have you evicted them? There is a decree of a decree, everything is there.
My instruction is that is another sort of.
Have you filed an affidavit? Okay. The learned counsel for representing the municipal board press for and is granted 2 weeks time to file affidavit in opposition. The interim order passed earlier shall continue until further notice. Yes, Talukdar, anything? What is the set of instructions? Do you dispute that?
I don't know how to resolve it.
Revenue. No, there is no problem. You book, book 200 families are there, no problem. This is not what is the subject matter of it. You verify whatever you want to do, you give them settlement. This is not the subject matter. Subject matter is that admittedly you have taken over the land in the year 1950, 51. Now from 1951 till date, nothing has been paid. Record, this letter says that record is to be scrutinized for the purpose of settlement of these families. Their record, whether they are refugees or not. That you have requisition, this letter is settled. There was civil suit by this party challenging requisition. This came to up to this court. This court upheld the requisition. Your deputy commissioner admits that yes, it is requisition. Your deputy commissioner admits that we are writing to the revenue department. So to regularize.
What you want of
Ceiling surplus.
that was not.
Now ceiling surplus, what was the ceiling surplus? Have you taken any action?
No, because of the pending of the court.
Whatsoever. Now what will happen to the suppose court case is over when? Not this court, that court of that civil suit. Civil suit is over. What is the status of
Appeal was filed.
appeal was also over. That is there. Now question is, what is the status of a ceiling case as on date? Mr. Khatanes,
My lord,
ceiling is
it doesn't come under ceiling.
because it is a special cultivation.
Yes.
Moment it is a special cultivation, it is excluded under Civil Ceiling Act.
My lord, even in their own order, my lord, passed by the collector, it says that this requisition land doesn't come under.
No, it cannot come because it is admittedly it's a land under special cultivation. So when it is land under special cultivation, it is excluded from the purview of the not only Ceiling Act, it is purview from the Temporary Settled Areas Tenancy Act. Many acts are excluded. Now, what should be the interim order today? Give us an assessment. What should be, forget about what should be the amount against rent. We just want the assessment. Forget about others. Suppose there is a land, you have requisition. What should be the, according to you, what is the rent? Seriously pursuing for what?
73 years.
Have a negotiated settlement. Otherwise, you will have to, it's a permanent measure. You will have to have a requisition. Now you will have to do it under 13 You pay the, if you go by law, pay the requisition amount till acquisition is initiated under 2013. As simple as. Have negotiated settlement under 26. That is the best option you are having.
government can very well come up with unique project.
We can
That's all.
settle the refugees, no problem on the, that requisition will not doubting because at that point of time it was
There
an
was-
emergency.
Influx,
Emergency, you need to settle refugee. This not only this land, many lands refugees will settle because this was an emergency, and in that case requisition can be
Yes.
done because it was a temporary affair. Give your land, we are giving you rent, but this has now become permanent,
going on perpetuate.
perpetuate. Until and unless you say that we are giving these people a different land and returning back this land to releasing it from requisition, giving back it to them and giving them the rent. Rent you will have to pay. There is no doubt about it.
Individual 2 acts have gone in 94 and
From
1940.
50, 48,
48
Okay, assuming that it was a requisition under the act, okay, you pay the rent and return, pay the rent, release the land to them.
they are taken.
Now, if you do that, that you will not do because people are already settled there. You will have to give a rehabilitation to them in some other places.
Schools have come up.
Under 13 acts are there.
No, don't take the name of 13. Yes, what should kind of order should we pass today? We are supposed to pass an interim order today. Therefore, for that we need some assessment that this should be the rent.
There was an assessment.
Where is
Make
that?
that at page 190. Sent by the circle officer to the for compensation. At page 197, it was valued at rupees 1,06,037 per bigha.
At that time.
Yes, in 2017.
Better go for negotiation. 190,
2017,
196.
page 196, annexure 38. And the amount is at 197, paragraph 4. Value of the proposed land is 1,06,037 per bigha. My lord, this is the assessment of the circle of on basis of the report of Mondal and Kano at market.
Halt. Mr. Commissioner, we are just waiting for a day because let us not pass an order which they cannot implement. Policies will be hard, Mr. Commissioner, Council for the place. Pursuant to this court's order dated 11/3/2024, the District Commissioner Nagaon has submitted a report, furnished a communication to Mr. P.J. Talukdar, Learned Senior Counsel, which is quoted herein below. Will record this. It's a different type. In the aforesaid backdrop, the Learned Standing Council for the Revenue and DM within bracket LANA department submits that a scrutiny committee will be constituted for verification of documents relating to requisition / acquisition of the land in question for the purpose of rehabilitation of altered refugee families. Though such letter is not clear as regards payment of compensation, the payment of rent for requisition or acquisition of the land. However, the proposal, however, however, can we say that the proposal itself indicates that they are proposing to have to permanently settle the refugees over the land? Why not? That was we are seeking rehabilitation where somewhere else. Then what is this instruction? Is it an instruction before a court? Forget about will be constituted committee. What is the reference to the committee? Is it a letter from a deputy secretary? Is it his understanding? What is his proposal? His proposal, he says that we are having a for verification of document relating to requisition, acquisition of the land, measuring so and so, so and so, for the purpose of rehabilitation. Now, there may be two meanings. One is that you will rehabilitate these 100 families over this plot of land. For that, you need to acquire this land. Or otherwise, you will take them to some other place and hand over the land to them with the areas of rent for requisition. Which one?
That order will make it higher for the
What is that? However, such communication is not clear whether the committee is being constituted for the purpose of rehabilitation of the rehabilitation of the families over the plot of land in question, or whether the government is releasing the land from requisition after payment of rent to the actual owner. Inasmuch as from the materials on record, including the communication of Deputy Commissioner, as quoted herein above, it is clear that the land was acquired for the purpose, land was requisition for the purpose of settlement of refugees in the year 1951, and till date, no payment, no requisition, rent for requisition has been made, nor the land has been acquired till date. Therefore, the state respondent shall clarify their position on the next date fixed, more particularly the following. 1. Whether the state is proposing to acquire the land which has been in occupation of the state and under requisition since the year 1951. Full stop. By whether the rent for requisition has already been, rent/compensation for requisition has already been determined, and if so, what is the amount thereof? Third, the state shall also file a detailed affidavit showing with a time frame showing their proposed action in respect of settlement of the claim of the petition. List this matter on after Bihu or after election. Because nobody is having any time to
process will not proper.
not proper. Okay. The already affidavit filed by the commissioner. Deputy commissioner has already filed an affidavit in opposition. In terms of the communication dated 15/3/2024, the deputy commissioner and quoted herein above, the deputy commissioner, not the district commissioner, district commissioner may file an additional affidavit. We will not give you right now. This is, we'll have a, or you can give us a Xerox copy of this. so that I can return. I think finance should also be involved in this case. Accordingly, though there was an observation was made for consideration of interim period in view of the appropriate development, same is not considered today and will be considered after filing of such. Last part of given date, 7, when? After 7 give it 13th. But this will take some time typing this order because it's a long everything. We want to keep it on record.
Otherwise also it's coming on PPT.
But still, last is the last instruction. Please come. Yes, what are these? Passover for the what is the issue here? Item number?
67. Their hands were occurred. No, it's not true.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after view. Yes, got it.
My lord, this case is the settlement of the very mall in respect of the private respondent matter. Before starting with the case, matter lord, kindly happen to order detail 26/4/2023
26/4/23
matter that will clarify entire episode of the case matter.
26/4/23.
My lord.
Press comparative statement.
Operative part lost to good be my lord. Para 5 months of the order.
Yes.
There, my lord, what happened, my lord, in the nutshell of the case, that, my lord, there is a notification as well as guideline. That before making any final settlement, my lord, and I am the highest 56. Settlement was given the 25 lakh. And he is enjoying, my lord. The fact remains that, my lord, there is a notification neighborhood are to be considered. Accordingly, my lord, that has been affirmed by the Honorable Single Judge also, that due to this particular fault. But when they filed an affidavit, my lord, it found and seen that it has not been examined and verified in respect of the petition. That is what, my lord, the last occasion, my lord, followed by the order dated 11th October, my lord. 11th October last order, my lord, was been directed to produce the original record. And whether any cooperative statement in pursuance to the order of the honorable
Yes, we need to record.
record. If it is that, my lord, it can go up to date.
Record it there. Yes.
Hearing on behalf of the teacher for the private account. They gave some difficulty.
You can want an adjournment.
My lord, I found him in the court, my lord. No problem. Yes, there. Not to can it be after tomorrow, past day, my lord. Because, my lord, they are enjoying the visit.
See,
Only
if he is seeking an adjournment, we will not waste time.
my lord. Your lordship is taking up the matter, my lord. I'll start. small issue, my lord, only that is the whether new comparative statement has been made or not. Or, my lord, they have visited my neighbor or not. If it
Okay.
is not that, my lord, it will go up.
Here the and here not submitting the neighbor side.
Who has given this record? Who are you?
So-
Who has given this record? You or he?
I am for the private.
Who have
Yes,
asked
sir.
you? Take your seat. Yes.
The government will say.
Go through the record and show us where is the comparative statement.
Comparative statement will not is the question.
No, no, we
Question is that-
understand that is that neighborhood was verified, whether neighborhood is verified for
In respect
each
of
and
three.
in respect of these people,
Yes, sir.
whether
That
that
is
has been verified.
The settlement of the 19. Put it for the 2.5.
How we understand that is your
That is the pandemic, my lord. Now, my lord, they are taking another plea, my lord, despite of fact that, my lord.
so
Honorable
meaning
Supreme Court-
thereby there was no verification of his society. That seems,
Oh,
since you are having a technical objection, that's it. Yes. Okay, okay. Okay, when?
Thursday, my lord. If, my lord,
Thursday, how many methods are there? May not be possible Thursday. Too many.
they are enjoying, my lord. I am.
They are enjoying,
I-
understand.
these are- My security money is also withdrawn.
So that we understand, Mr. Borbuya.
Lordship.
You also,
Lordship,
we are not,
I'm lordship convenient, my lord, Tuesday and Thursday. Any. Lord.
first week of April,
At that point, to be cleared, my no further adjournment.
4th of April. Okay, the record of the let's record pertaining to the settlement. It is stated that record pertaining to the settlement has been received by the government, and Mr. Dean Atlanet, senior government, is dealing with the matter and he is on legs in some other court. Accordingly, an adjournment is sought. At the same time, it is submitted that Mr. D. Atlanet, senior counsel, representing the
Private respondent.
private respondent, is also having some personal difficulty. Accordingly, a prayer for adjournment is made. Mr.
Petitioner item 9.
The third.
Okay. What is your ranking?
Second.
You are
He's the
second.
second, I am the first, he is the third.
Okay. So why she is here?
He is, my lord, also one of the petitioner leading.
No, understand.
by
Okay,
Mr.
okay. We will not concentrate on that. Equal. Mrs. J.I. Borbuya, however, Planet Council submits that the petitioner being, despite being highest bidder, has been deprived of the settlement illegally, and therefore he has expressed some urgency in this matter. Considering the matter in entirety, a prayer for adjournment is granted, fixing the matter on 4th of April. See, how many matters are there? You have fixed many matters on 4th of April.
Lord, it will not take much time, my lord.
No, it's not an issue. See, today also so many matters
Okay.
fixed now. It's a difficult. Now we will not be able to complete the list. Huh? 16th of April. No, instead of today is the CP already 16 matters. Okay. These 16 matters are important matters.
On that, my lord, and over to be made to dispose of the matter.
4th of that will not say.
Or
We'll
no
do
adjournment,
that.
Lord, either say
4th of
any-
April. 4th of April.
No,
There shall not be any adjournment on the day.
my lord, that order be given, my lord.
Not necessary.
Not-
We are not shying away. We are taking up this matter.
Put the-
9th.
Question I took. A lot of matter. Publish.
Yes, what is this?
Check my that. And that year has already been approved. Just for 20 to 20. Validity is not.
Okay. Learned counsel for the petitioner submits that. That's why we say that this is in ventilation on last occasion. Your junior sought for an adjournment. We said we do not need Mr. Biswas This was already in ventilation. It's
Means that-
submitted by Mr. Learned Counsel for the petitioner that this matter has become infructuous. Accordingly, the petition stands closed being infructuous, interim order passed earlier, if any, stands vacated.
As the tender period has been attended.
As the tender period has been, in the meantime, become infructuous as the tender period has already. Okay, as agreed to by the learned counsel for the parties, please this matter after view packet. After 22nd of April. Do you need a fixed date? Okay, give a date, last part of the April. 29th of April. Yes, Mr. Sharma, possible today?
I am for the respondent number 4.
What is the issue here?
They are repeating. Suit is pending. I had filed a
Land has been declared, compensation award declared, my lord.
In your favor.
After award, my lord, they file.
What the law says?
They can go for reference, my lord.
lordship
There is
is
no, my lord,
until the book.
because they have filed suit after, my lord, compensation has been granted. And it was proposed to be released.
Lordship title is not yet declared.
No,
The
title is
very
not,
fact they have raised in their petition is that
no, title is not declared. Issue here is this. A land acquisition notice was issued when?
not to us.
Not to us. When notice?
Subsequently came to know.
No. Forget about that. For the time being, tell us when the notice of the land acquisition under which act? Mr.
Act
Ali.
of
Land was
13.
secured, my lord,
Yes,
under
Huh?
Assam Land Acquisition and Acquisition, my lord, 1964.
1964 Act. When notice was issued?
And
Huh?
31/12.
31/12/2023. Okay. 2000 3001 23. 38th of January 2023. When the award was passed? Mr. Ali,
Lord.
these are the vital question in this case.
Award passed, my lord, 2012, my lord, page
2000
22.
notice was issued on 2023. How award? Huh?
Yes. Notice for, my lord, notice for compensation was
Notice of acquisition which was issued when?
my lord, in 2022, my
Date.
date.
On the prayer of the learned counsel for the parties, please this matter after package.
After vacation.
Yes, you vacate.
Date may be fixed out.
Give a date. 19.
19.
Mr. Ali, issue is moment a notice is issued, objection is sought, and after the second notice, the land is vested in the government. Okay. Thereafter, an award is passed. In the stage of award, somebody can raise. That includes that objection includes for apportionment, for entitlement, for enhancement. Okay. In either of the cases, the deputy commissioner is to refer the matter to the referral court. Now, referral court will decide whether he is entitled or not. Mr. Sharma,
That is the procedure.
procedure. Now, suit was filed on which date?
It was filed on the month of August.
After
23.
these are the vital dates for determination. We are with this list.
When
We
the
don't have
person
that
came
much
for-
of time to go through every date.
Lordship,
Yes,
when the
next case.
person came for physical verification,
Next case.
then
next
only
case.
came to know you.
But whether you suit or you file a deputy commissioner,
We were completely, Your Honor, back on the site, Your Honor. We are not known, Your Honor. This
who will decide that? Where is the decision of title?
Our-
Title is vested in the state.
Lordship, think is that we are the original
Yes,
owner,
yes,
Your Honor.
yeah.
We
He
are
is
the
not
original
asking
owner.
what to
That
do
is to
next.
be decided.
29th. Okay. Yes, what is this?
35 plots of land,
Hmm.
the industrial nature is acquired by the National Highway Authority of India.
Hmm.
Land has been identified as a agricultural land, instead of the industrial.
Notice was issued for industrial or agriculture.
So
When the notice was issued for acquisition, it was industrial in the notification or agricultural.
they identified as a agriculture, but the revenue authority of the concerned district.
My question is, when a land is acquired, it is under Highways Act, there should be a notice. Notice describe the land as a agricultural land or
Agriculture.
agriculture. Did you file any objection in terms
Objection,
of the? You have filed an objection. Now they have not acceded to your request.
Yes.
And accordingly, what they have done is
Fine.
you have
Find out, fine.
they have determined the compensation by the Kala as an agricultural land. Is not it?
Yes.
Now what is your remedy?
Not,
3G5.
not the same. Report as part of section 3. Before determining the compensation amount, notice has to be issued in terms of the section 3.
3G.
That notice has not been.
Then what are you saying? That's why I have asked what was the description of the land in the notice?
I-
Where is the you have
I
not issued any notice under 3.2.
3.2 notice. It is issued in 3D notice that I have annexed.
Where is that your notice?
You will find in the page
Highway
number.
check, highway check.
Page 18 is a 3D. It's not 3D of that.
You have become a referral court. According to you, which notice was not issued?
It's under section 3C3. Report proceeding to determine the amount under subsection 1 or subsection 2. The competent
Just a-
authority shall give a public
Just a minute,
notice.
just a minute. According to you, this notice is under
Section 3C3.
3D.
I am referring the text section 3C.
See, as per this notice on 19/3/2023, a notice under subsection 3 of section 3A was issued. Okay. Subsection 3 of 3A is an intention to acquire, that we are intending to acquire this land for this purpose. Okay.
Yes.
Thereafter, what notice should be issued?
Thereafter, section 3C. It is for the carrying of objects.
No, there is no notice. This, on the basis of this notice, they will survey any person interested within 20 days of publication of notice under subsection 1 of section 3A may file an objection. Did you file any objection? You file an objection. Now, this notice is under subsection 3D1,
It is the land is vested with the
central government. Now 3D2. Under 3D2, this is a notice under 3D2.
that part of my.
No, page 18 is a 3D2. So it is declared that it has vested in the government. Now what is your design?
First,
Where is your land? Show us. 1946. Agricultural.
1946, 1948, and 1952, 1956, 1956. That's the 5 sorts.
Now what is your remedy? Now the possession has been taken over.
No.
This is for national highway.
Yes.
Okay. Yes, madam, are you ready?
Because it-
Who is your senior? Forget about our capital. We are already spent 5 minutes. Yes, now tell us.
Lordship, there is very the competent authority may be directed to consider my objection because when I filed objection, they did not conduct any hearing.
Under which provision they will do hearing?
Now they
No award is passed.
know about,
Yes, madam.
but the
No award is passed.
but officially it has not been communicated to me
But you are aware that award is passed.
because it is declared by by them in the last occasion.
That-
The amount is it is recorded in the order itself.
So if amount is determined, now we have no way out but to send you under 3G5.
So that is the issue mandate of the law is that the notice before determining the amount,
Hmm.
the notice has to be as part of section 3G2. So it is the mandate of the law, it cannot be ignored. And the admitted position is that
There is no mandate of any notice under 3G. 3G is a principle on the basis of which the competent authority shall determine the compensation. That compensation, if determination is wrong, then you have a remedy under 3G5.
arbitrate.
Understand? Isn't it? So go to the competent authority under 3G5.
Just one minute. If the amount is determined by the competent authority under section so and so is not applicable to either of the parties.
Not
the amount-
acceptable. This is not acceptable you because they have determined industrial land to be agricultural.
Correct.
So go to that provision to that authority.
That authority is the arbitrator.
Then
Then arbitrator is yet to be appointed.
no that they have appointed. They have appointed.
Not appointed.
Yes.
If he is appointed, then all right, Lordship. I'll approve that.
That is what we are trying to let you understand.
My
Heard Mr. So and so learned counsel for the petitioner. Just listen to my order.
Yes.
The grievance of the petitioner is that all these petitioners are before in joint petition.
No, single. I am the owner of
All you are the owner. Zakir Hussain.
package.
Zakir Hussain. The grievance of the petitioner is that 5 plots of land, 1, 2, 3, 4, 5. 5 plots of land has been acquired by the National Highways Authority in terms of National Highways Act 1956. Full stop. According to him, pursuant to a notice issued under section 3A uh, 3D on 3A1, the petitioner filed an objection registering his objection that though the land sought to be acquired are industrial land, however, those have been shown to be agricultural land in the notice issued under notice issued under the Highways Act for acquisition. Full stop. During the pendency of this writ petition, a statement has been made that already award has been passed in this regard.
Lordship, that is not officially communicated. to me.
Award has been passed. However, the learned counsel for the petitioner submits that he is not aware of such award. Full stop. Where is Talukdar? Typical. You would have told us immediately. Huh? In absence of him, it's a difficult order to get. Though it's a, we cannot say he's present. When he's coming? Mr. Sharma? Day after tomorrow? Friday? You have a instruction also. Because in absence of him, we cannot record that award has been passed. That is the difficulty. Though there are something has been recorded earlier in his absence.
I have thought it,
I have seen that. Okay. This method day after tomorrow. Friday. Madam, tell him that he should be ready with the instruction what has been directed by the court earlier. Put a specific that whether award is passed or not. That we can have that construction during that.
arbitrator by the
No, arbitrator has been appointed. We know that because in pursuance of our order that has been passed. Yes, special secretary. Yes, recently we know that. That has been. Yes. Again, yes.
If you input from me, Lordship, only.
Huh?
You input from me.
From input from you only.
I have got a
Where is your objection?
page 39.
Page 41 is filed by whom? Page 39 is by whom?
Petitioner.
Petitioner. You are Abul Hussain.
Hello.
Now award is passed in whose favor?
our
Now what is the dispute? That has been passed in your favor. They raises an objection.
object because they have purchased
Ah.
by unregistered.
So whatsoever matter has been referred to the arbitrator.
No. Has to be referred. That is our
Has to be referred. No, yeah. Under which act?
1960.
1964 Act.
Give the 1964. And what you want to say?
Lordship, it is the land acquisition officer's duty is to refer if the question of title arises. That is the question. one decision I got that the awardee, if does not accept, then it's condition precedent, they must be award, but it is in a constant award.
No, not that. That's not right. Requisition.
It is in a constant award. Secondly, in their repetition, they have specifically mentioned by a unregistered deed. I have said the law is clear. There is admission there. Unregistered deed does not confer any title.
Do you propose to say that we'll make a determination in report that unregistered sale deed does not confer
It
any
is not
right?
disputed.
Huh?
I am submitting because it is disputed. In their repetition, they have taken.
No, no, it is admitted. Assuming for a moment, land acquisition is something different. Even in an admission, that suppose they file a written statement that unequivocal, because admissions are also some qualifications under the CPC. We are in a writ court. Forget about the applicability of.
Yes.
Isn't it? So we'll dictate this order. Give the judgment. And what are the judgments from you?
Regarding the role of deputy commissioner,
Not role of deputy commissioner. What will be done when there is a counter claim?
that role of
Ah,
to
This
refer
first page from 10th. This is against me, but the land acquisition commission has determined the extent of the land the person entitled to compensate and the compensation determined at 21.
this was what we are saying to Mr. Ali in the last case. If we'll have to bring the judgments from law for lawyer, this is the law. Because the moment acquisition first notice, second notice is given, land is vested in the state. So where is the determination of title? Whatever is to be determined on the basis of claim or title is the compensation. That is to be done by a competent court, which is a district judge. It has having all power, including taking evidence. They will take evidence. You will say that this is an unregistered sale. Matter and step. Hard.
And reference court can decide the title.
Yes, everything. That is the law. But on that day, this was not. This is in his favor. His favor.
On that day, I submitted the reference court cannot.
You made a submission, but we as a judge don't have the judgments in that way. Na? We know the law, but the problem is that we cannot cite. That cannot be hard. Mr. H.R. Ahmed, Learned Counsel for the petitioner. Revenue. Revenue. Madam Hazarika. G. Hazarika, Learned Standing Counsel for Revenue Department for the respondent number 1. Mr. H. Sharma, Learned Government Advocate for the respondent number 2, 3, and 4. Mr. S. D. Purakasta, Learned Counsel for the respondent number 6 and 7. Who is for respondent number 8?
8 record.
You are for 5. You are Mr. M.M. Jaman for respondent number 5. And who is A. Deka?
It is not here.
He is in the court campus? No.
He was there in the court campus. Right now, I cannot say. He left.
He
Otherwise,
he entered to the
Entered,
High
entered.
Court premises
Exactly.
today. Okay. Mr. A. Deka, Learned Counsel for the respondent number 8. The grievance of the petitioner is that the petitioner is an person interested. So far, it relates to acquisition of land under LA case number 5 of 2021. Full stop. And he claims compensation. Claims compensation. Claims compensation for the land acquired. Full stop. From the affidavit of Additional Deputy Commissioner Kamrup Guwahati, it is seen that an award for an amount of rupees 26,37,440 was passed in the aforesaid LA case in favor of the recorded purchaser, that is respondent Amir Hussain. Who is Amir Hussain?
Our father.
Respondent, predecessor in interest of respondent
8.
number 6, 7, and 8. 6, 7, and 8. Full stop. Where is the huh? Page 30. Full stop. The claim of the petitioner was rejected by an order dated 15/7/2022 by the Additional Deputy Commissioner Kamrup Amingao, rejecting claim of the petitioner was rejected. Full stop. In under the scheme of the Assam acquisition and requisition of 1964. The give the book. Give the give the give that. Section 12. Huh? Power to pass the award. No, not reference. Award. 11.
Equity.
No, power to pass an award.
Power to requisition.
The collector is empowered after adherence of due procedure as mandated under section 6 and 9 of the Act. The Deputy Commissioner is empowered to pass an award under section 11(1). Not Deputy Commissioner, the collector is empowered to pass an award under section 11(1) of the Act. In the case in hand, it is an admitted position that award has already been passed in exercise of power under section 11 within bracket 1 of the Act. When the section 12 of the Act further mandates that when any person is aggrieved by an award made under subsection 3 of section 11 makes an application disagreeing with regard to the compensation payable under subsection 4 of section 11 on the application of the person entitled to compensation requiring the matter to be referred to the court, the Deputy Commissioner is to refer the matter to the referral court. However, in the case in hand, the collector himself has taken a decision as regards the entitlement of compensation made by the petitioner. The right course of action in the given facts of the present case is to treat the application filed by the petitioner as application under section 12(1) of the Act 1964 and refer the matter to the referral court. The law is well settled that the dispute as to the person entitled to receive the compensation is to be determined by the referral court, and the collector is not empowered to decide such dispute but to refer such dispute to the referral court. That being the position, the impugned order dated so is not sustainable under the scheme of Land Acquisition Act 2020. More particularly, in view of the provision of Section 12 of the Act. Accordingly, the impugned order is set aside at first. The collector is directed to treat the application filed by the petitioner dated Twenty 20 as an send the same to the referral court within a period of 60 days from date of receipt of the copy of this order by the collector to be furnished by the petitioner. Hmm. Okay. Mr. J. Henry Clarnet Council submits that pursuant to this court order dated 13/3/2024, he has received the report from the electrical inspector, electrical inspector, and would like to bring the same on record by way of an affidavit. Prayer is allowed, list this matter. Keep a date after vacation. But what is the report?
I have not got.
Okay, we'll go through it. We will not waste time. If we are determining, we'll see, otherwise not.
Sure.
Give a date. 23rd of it. You file the affidavit.
Definitely.
It's long pending. Yes.
You can ask order.
Assessment register in respect of building.
I have the assessment register, madam. It's as big as a 52-inch CP, madam. I have taken my car, but this is the
What is the issue here?
Paper
Ah.
you by the respect dot permission.
Ah.
But because of the inaccuracy for some of the control, direction of the court, both TMK, the TMK cluster inspect, TMK paper by the new respect as but that affidavit is and it that pursuant to throughput of that he has only constructed, renovated the front part, not constructed anything, and the permission is on the basis of 1990. So, and TMC has report stating it is as per 1990. Therefore, there was question whether in 1990 there was assessment of D plus 3 or 4, D plus 3 building, because if our contested is that
No building was there.
no building was there. I have given photograph of 2012, because what was happened in 2012, I had taken permission for construction of shop in front of my property. So while that I had taken permission, it also submitted photograph. Those photographs are here. There was no building there. So on the basis of that,
Now, what is the report?
TMC's report is that a building was there, and this is the now the 2 6 have been given, madam. This is the assessment list of the building. What you will see the top, madam. Fourth quarter of 2007-2008. This is the assessment that the building was there.
What was the building as on date?
this is a C plus 3 building.
Hmm?
C plus 3.
D plus 2.
Yeah, in the assessment list of fourth quarter of 2007-2008 is D plus.
Now, can you summarize whatever is in the report and file an affidavit?
No, this affidavit will file.
No.
File and the report is.
No, that assessment register. Assessment register is assessment. What is it is in your assessment?
Assessment register is that there is a building, earlier there is a building and it has been assessed, and the one extract of the assessment building year of.
Okay, you bring on it on affidavit. It is submitted by Mr. S. Bora, Learned Counsel, for the respondent that he has received the assessment register in respect of the building of respondent number 5. However, it is very voluminous and he would Voluminous. Full stop. Be that as it may,
Well,
let,
number 7.
seven.
Seven.
Response 7, I said response 7. Be that as it may, let an affidavit be filed by the DMC summarizing the assessment and their findings in it. From the year
We
19.
have the aspect of 2000, that building has been assessed on 2007, 2008. That is it. Maybe, maybe one of the assessed on the start.
Okay, we'll have this. Okay, from 1990. You want a copy? This copy? Yes, next. List after.
In this case, Lordship, morning, that Contempt Chaudhary Lordship, we are suffering from, and they mentioned, but as because the matter is of 2013,
Who is he? He is representing whom?
the Royal Coal Product and another Lordship is the writ petition. On the earlier days, Lordship, we have been direct. अपनी क्यों क्यों रहता है?
So according to the Coal India, that belongs to Coal India and there is no, they don't have any right. Any interim order?
It's because they are already demolished, Lordship. From the writ petition, it reflects that already that demolition is over. Now they are claiming compensation in the writ petition if we go by the prayer portion of it. Prayer at page 18. Whether this Lordship calculation of this compensation, whether this court is competent.
More particularly in a given stand, they have said that this land belongs to us. So it is to be determined whether it lands belongs to whom and if it is whether it was legal or illegal.
Lord.
That will require factual assertion by evidence.
Lord.
So we are closing it. No way out. We are not giving any journal.
Lordship,
Let it be tested.
may I suggest, Lordship? Lordship may keep it as a part that without him, Lordship is suffering from. That he will request the Lordship, otherwise he will be in. Let it be kept as part heard, Lord. As because your Lordship are hard it. On Friday, Lord. I will not be available tomorrow and next.
Certain things, Mr. Sharma, when your artery is clogged, your heart will stop. You will have to clear your artery. Then there will be flow of fresh blood, then you will survive. Now these cases are clogging the artery. Otherwise, easily we can give an adjournment. There is no problem on that. It's not that we are not done our job. We have done our job till 3:30.
That's true, Lordship. But he made a request.
I can issue, I will adjourn it for Friday. You need not come. We will record your name.
On Friday, I am available, Lord.
No, I'm not saying. I'm saying about the thing.
Oh,
He's also ready. So your stand in the repetition. Affidavit. That it's your land.
It is 18-1.
18-1. Mr. Sharma, we have abandoned these papers long back.
Lord.
And for these petitions, now I'm sneezing. Have you seen me?
Sanitizer in addition to sanitizer.
Even sanitizer is not doing anything. All these dusty papers. Anyway, which order? 20?
18-1.
18-1-24.
have been directed to do certain instructions.
See, suppose there are,
Lord,
we are not going to all the
Lord. That is why I am testing the prayer portion.
that can be determined there. You have taken,
Lord.
yes, circle officer has taken a statement on the basis. Is submitted that Mr. A.K. Chaudhary, learned counsel, is having some personal difficulty and according to prayer for adjournment. Though this court is not inclined to adjourn this petition pertaining to the year 2030. However, considering the ground that the learned counsel is not thinking well, the matter can adjourn and be listed on Friday.
Friday, Lord,
Friday.
available.
Listed on Friday. Uh, 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 if the learned counsel remains unwell, the petitioner may arrange for some alternative.
We take.
Yes.
If I have prepared the list of dates, I'll post that.
Third, Mr. Swami, escape Swami, learned counsel for the petitioner. Also third, the eight Sharma, sorry, eight Sharma, learned petitioner is given government from the state of none appears for the private account. The present writ petition is filed assailing an order dated, a judgment dated. Mr.
2407.
Where is that? Just give me the
Page 45.
page
45.
24/2007. 24/2007 passed by the Assam Board of Revenue in case number 98 RA within bracket NL plus space 006. Full stop. A sole sale notice dated 12/1/72. 12/1. What was the sale notice? Salience in the
Sale case number 58 of 7071. First side.
an order dated 12/1/1970. No. The aforesaid appeal was preferred against an order passed by Deputy Commissioner Narvali in sale case number 508/1970-1971, whereby sale dated 12/1/1972 was interfered with. Full stop. Interfered with. The basic ground of challenge is that the Assam Board of Revenue has exceeded in its jurisdiction by while entertaining the aforesaid appeal for the reason that the appeal was preferred after 32 years of the sale that was conducted, and more particularly in a given fact that a salience made to such sale by the state respondent was negated by the same Board of Revenue in a case being
But we'll find
7, it was negated by Board of Revenue,
in state setting
order dated
by order dated
2/2/83.
2/2/83 20 2 1983 passed in
RA 129 K 1980.
RA
129
129 RA
K
K
1980.
19. Ask him to keep the clip. Okay. The background fact of the litigation, which is discernible from the record as well as from the order passed earlier by this court in Civil Rule number 843/1983 and Civil Rule number 842/1982 83 preferred by the state of Assam against the earlier order of the Board of Revenue dated 2/2/83. The following facts can be summarized. Okay. In the aforesaid backdrop, which is the the aforesaid backdrop, no, summarize that the cell case number 508/7071 in auction sale case number 508/7071, the your predecessor in interest, predecessor in interest of the present petitioner purchased the land. Full stop. Sale certificate was issued on 8/4/1972. Full stop. Such auction sale was challenged by the government of Assam by filing an appeal before the Board of Revenue, which was numbered as 129 RA within bracket K/1982 within bracket State of Assam and itu pura लिख लो हाँ pencil pencil complete not note करें ठीक है. The Board of Revenue, by common judgment dated 2/2/1983, dismissed both the appeals. Being aggrieved, the state of Assam approached this court by filing Civil Rule number 842/1983 and Civil Rule number 843/1983. This court remanded the matter back to the Board of Revenue by setting aside the dismissal order dated 2/2/1983. Thereafter, on being remanded, the Board of Revenue once again dismissed both the appeals under its order dated 17/11/2003. Thus, the sale dated appeal, the state of Assam did not prefer did not make any challenge to such decision of the Board of Revenue. Thus, the sale in question attained finally. Subsequently, the respondent number, predecessor in interest of the respondent number, respondent number 4 preferred Uh, Preferred RA 98 NL slash 2006 with a petition for condonation of delay of 32 years. Such delay was condoned by the Board of Revenue and the appeal was dismissed. The appeal was allowed by setting aside the sale. Full stop. The fact remains that in the meantime, the state acquired the land in question from the land in question by paying compensation to some of the to the person who purchased the land under the sale which was challenged by the state.
Land acquisition case number 9 of 2005.
In line land acquisition case number 9 of 2005. The Board of Revenue has condoned the delay of 32 years and allowed the appeal by way of the impugned judgment on the ground that no notice was served to the predecessor in interest of the respondent number 4. However, from the judgment of civil, he itself is a okay, not the predecessor in interest, respondent number 4. Huh? I'll correct it. I'll remember. However, from the judgment passed by this court in civil rule number 842 of 1983 and civil rule number 842 of 1983, it is seen that the said respondent number 4 has himself received compensation on 13/11/1995 from the land acquisition officer. Land acquisition officer. That apart, the method as regards the validity of the sale was determined by the Board of Revenue after remand from this court, and such sale was not interfered with. And such fact was also brought to the notice of the Assam Board of Revenue. However, the Board of Revenue has ignored such proposal. Full stop.
That cannot be transferred against the party.
Full stop. Mr. Sharma, learned counsel for the state, submits that the state has already acquired the land and the PWD house, PWD building and quarters are housed in the aforesaid plot of land. Full stop. Accordingly, in view of the totality of the matter, this court is of the unhesitant view that the Board of Revenue exceeded in its jurisdiction by setting aside the sale in question, more particularly by ignoring the determination made by the same Board of Revenue in the earlier proceeding and challenge made to the same sale process. Further, the fact also remains that the land has already been acquired by the state and compensation has also been paid not only to the present
Compensation has been paid to the co after that.
compensation has been paid to the you have also received.
My money is paying because of it.
Okay, compensation has been paid, and so far relating to the compensation as regards the present petitioner, same has not been released for the pendency of this writ petition. Full stop. Accordingly, the present writ petition stands. For the reasons discussed here in above, the present writ petition stands allowed by setting aside the impugned order dated 2020, passed in 2020. Interim order, if any, then.
Okay.
Mr. Goswami, it may take some fine tuning from the
So I
judgment and all, it may take a week's time.
amount was likely to accepted.
So you said interim order stands vacated.
Okay.
Yes,
Lordship, on behalf of our learned additional ATPN, document for today was
what is the issue here?
13-year-old boy was kept in police stock, and then thereafter he was sent to jail. That is the main issue.
My lord,
So who are you?
Lordship, I am appearing on behalf of additional ATPN to submit.
Yes.
He was appointed as an amicus for
No, it was not the state. The came to entrusted the plea. What it told me. Considering that it's a sort of what it it's a date,
What is the prayer?
there is basically compensation. There your lordship will find that page number.
What is the state in the affidavit?
Initially they were in a denial mode.
Huh.
Subsequently, this honorable court said produce the report, medical report. When the medical report came, everything became clear.
Then?
And then now it is fit for death. So there are two affidavits. The first affidavit was filed on 24/2/2015. There they were in the denial.
Then?
And then this honorable court said you filed an affidavit annexing the medical report. In that medical report, my lord, everything came.
Where is that medical report?
My lord, my lord, page number 3, my lord, there's an affidavit which was filed by
Deputy
the,
Commissioner.
Deputy Commissioner Karbi Anglong in terms of the order dated 19/7/2017. And there's a page, the last page of that affidavit. At the, my lord, bottom, from the above findings, the age of the person is
Space.
my lord, page number 3, the last page, my
Page 3. Name of the UTP.
name of the UTP, that is the petitioner number 2. And at the bottom, my lord, from the above findings, the age of the person is estimated to be below 14 years. That means he was 13 years of age.
Yes, why should we wait for additional advocacy? If you will not make affidavit, there will decide this. This is an UTP. Rohit Mes, UTP, do you know the meaning of the UTP? Under trial prisoner. And he was produced from jail. And these are his injuries. His age is 14. What further deliberation is required? Who put him behind bars?
My lord, there's one forwarding. What it appears, my lord, page number 21 is the forwarding. If your lordship kindly see,
Page number
21, my lord.
third.
Page number 21.
Third in part. List this matter for further hearing on 27th.
Apply.
We'll expect the additional advocate general to assist us, not to litigate. Yes. 27th, this month. Yes, what is this?
Declared at the town committee. 24 of the.
Okay, town committee means inside,
not
in-
correct,
inside your,
township.
this is hearing,
This-
may not be possible today. It needs some delivery. What is your stand?
that in the
Government-
affidavit is nowhere.
But therefore, there is a direction whether,
Produce the record.
what is the record?
Records are here, but.
Whether that notification was there.
Notification declaring.
That,
the town committee
that their object,
consideration of the objection.
objection
Right.
considered.
The order does not reflect that. Order says nothing was received.
Now suppose that was not even considered. Assuming for a moment, record says that your thing is there and while deciding or finalizing the issue, it was not even considered. What will be the course of action for this?
Therefore, that matter, I'll rely upon a division bench judgment of this.
What it says,
It says that it is bad in law it to be done.
so it will be void ab initio. So it will
Some-
be out.
Some parties were.
Okay, due to paucity of time, this matter
The division bench has held my lord that the best object is to provide better facilities. If those facilities are already in existence, maintained, what is the requirement? That is the basic object.
may not be possible
May
today,
not be possible.
because ultimately this will have a far-reaching consequences. You'll have to make a pre-judgment order, go through the record and all.
Yes.
It's submitted at pursuant to this court's order dated 8/2/2024. And 12/3/2024. So, not like a 12/3. 8/2/2024. The record has been received. So Mr. Talukdar, Planet Senior submitted, he may be allowed some time to go to the record. Prayer is allowed. The learned senior counsel may also. You also let him also go through the learned. Some time to go through the record. Prayer is allowed. Prayer is allowed. The learned counsel for the petitioner is also permitted to go through the record in presence of the learned senior. Is this matter after
On 27th, I have some personal difficulty on any other day.
after behavior
After on 23rd or 25th,
25th possible
23rd, 23rd of April.
23rd of it. Yes, what happened to Jalan?
After the maximum number 41 to 47.
Hmm.
14 the Kamadia. On the last day, 30 to 2024, was an order passed by saying that one of the finance
Read file. Urban. Housing and urban affairs.
is not filed. Otherwise, Dr. May have a passport for the claim.
Under prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after behalf. Anything survived?
The petition
Okay,
interim order.
26th of April.
Interim order.
Interim order path shall continue till the next. Why? Everybody expected that no matter will not be, isn't it? Or what happened? Nobody is here. It's 2016 matter, 15 matter. Can you make a determination? Okay.
I've got the instruction,
What is your instruction?
but I'm not very satisfied with the instruction because the person who was actually drafting the instruction, the midway he has to leave.
So,
And another person has written.
Mr. Bhattacharya, Learned Counsel, A. Bhattacharya, Learned Counsel, appearing on behalf of respondent number 2, submits that though he has obtained instruction in terms of this court's order dated 29/2/2024, same is not complete. Accordingly, he seeks for an action. Prayer is allowed. Please this matter after due vacation. On the next date fixed, on the next date of listing, Mr. Bhattacharya shall obtain instruction in terms of this court, obtain complete instruction in terms of this court order dated 29/2/22. What are the issues here?
Regarding both here. Of
So according to you, that bar under subsection 2 was brought when?
Four, four,
So the bar was when?
20, amended,
2016 amended.
amended
And there is a bar
on retrospective, that is our
on retrospective effect. Since it is not prospective, it is always retrospective. And that debars to purchase property even in the name of unmarried daughter. But according to you, your property was bought in the year 2011. And at that time, there was no bar to purchase in the name of daughter. None, you are Mr. Gautam and Gautam, learned counsel for the petitioner is present. None appears for the income tax department. Mr. J. Hendik is present for the respondent number 3, deputy commissioner. Who has issued this notice? Who has issued this notice?
complaint.
Income tax means
Page number 20.
However, none appears for the respondent number 1 and 2 who has issued the notice. Why this matter is admitted or what? Okay, for hearing, okay. Okay. As the presence of the aforesaid two respondents are necessary, in the interest of justice, matters definitely. The interim order passed earlier by this court on 20/05/2020 shall shall continue until further order. That's it, until further order. That's it. Interim order part earlier, no date should be given. Okay, or parts earlier. In these cases, continue until further.